Colleagues,
I wanted to mention one matter.
Thursday. Yes,
May I privilege for a
mention on Thursday.
I am praying for leave for the file of memorandum of appeal without certified copy, my lord. Ready? I have already
When was the order passed?
26 August 2025. So my lord, is some urgency here. My preferred school will be
Yes,
my lord.
তো কালকেই হইবে।
Not to it.
Petitioner Lordship. Lordship, it is the matter in which the husband of the petitioner passed away without exercising option from CPF to GPF. After that, the widow has applied for the pension. Lordship, I have come across a judgment passed by the division bench of this court, Lordship, where the widow was allowed to opt for the option upon refund of the provident fund with interest, Lordship.
You are appearing.
My lord, last time your lordship asked for Vijit Boydo, the government circular. This is I have collected from the department.
After the issuance of this government order on 13 June 2014, the widow has applied for the pension, Lordship.
Did you apply within 3 months?
Your Lordship, the husband expired just
Expired in 2014.
14. After the government order.
7 was retired. Expired in 2014.
Yes, Lordship. After the 13 June 2014 government notification was issued, Lordship, immediately from July, I was applying for the pension, Lordship. The series of representation is annexed in the petition.
But not within 3 months.
No, Lordship.
Then how can the time be extended now? How can we extend the time, madam? This is show us any instance that this 3 months period has been extended, then you get the benefit. Because that is the finding of. I don't know what are the facts of this case. When was it? This is a group of petitions.
Yes, Lordship.
This is a group of petitions wherein.
Lordship, in this matter, the widow have been applied for option
I don't know that. How you also do not know that.
from the
So
first.
check up the brief. Check up the file then. When was the, because this is a composite application. Where
Order is available, so I could find out from first two paragraphs that the writ petitions were.
there is no finding in this order subject to what you say that even if an application was made subsequent to 3 months, it will be entertained. We don't, you apprise us, is there any circular? You can also help us.
No, my lord, already 30th September 2007 retired, and after about 27 January 2014 already expired.
Yes,
But before that, he could not submit the option form.
maybe, but now in terms of the 13 June circular, time was given to the widows to apply.
Not applied till now. Would also not applied.
No, then you check the particulars of this case which he has cited. Please check it up. Ascertain from your director of school education whether this three months period is mandatory or not, or whether I don't know what is the government circular at present. Please ascertain that and come. Give a copy of that order to him.
My lord, one school authority submit the report and they pass the resolution on 27 August
Then you
2014.
then you file an opposition to the stay application, disclosing your stand.
So, my lord,
He
conducted one order.
But বলিও না।
My lord, the Shefali, the state of West Bengal Shefali Jana. This case already allowed the petitioner to submit.
So why this case will not be allowed?
So far, just I came to know that to collect the order, one of the order. Have you submitted?
না এক্ষুনি পেয়েছি এখানে দুটো প্যারাগ্রাফে দিয়েছে
Passed by the Honorable Justice Rajshekar Mahato and Supratim Bhattacharya.
এটার বেসিসে যদি বলে দেন হবে কিনা
সাথে দাও।
হ্যাঁ হ্যাঁ
হচ্ছে
জজকে দিয়েছি আমি
Regarding the
যশোর
ইডোর ব্যাপারে
Obijit Boito, what I already handed over, my lord. The Obijit Boito case, Supra judgment within a period of 3 months from the date.
3 months. 3 months from what? 3 months from the date of issuance of the window for extension of time, the widows applied. Order was modified to that effect. Unless you bring us those facts, how can we assist you? The present appeal has been preferred.
Senior Advocate Jayantanaran Chatterjee is leading item
I'm
number
for the
3
state,
and
madam.
4. So I am praying not this week, Lordship.
You are for the state?
I'm for the state, my lord. I'm led by Mr. Shogoto Mitro, my lord.
Huh?
My lord, I'm for the state, my lord. I'm led by Mr. Shogoto Mitro, my lord.
What is the issue? What was the read petition about?
Lordship, the matter is related with CPF conversion of CPF from the GPF.
CPF.
Now, I have filed one substitution petition because the read petition was decided on 17th of January 2025. In the meantime, the petitioner was died after the filing of appeal, this present appeal.
Have you
But-
served
Yes, Lordship.
substitution application?
Yes, yes.
No substitution application has been served to
Yes,
us.
Lordship. In the meantime, the appellant was died and the heirs of the appellant has filed this substitution
Appellant died
petition.
after filing of the
Yes,
appeal.
yes, Lordship.
You have not given a copy.
No, my lord. Substitution application.
Yes, sir. I'm
Where
giving.
is your affidavit of service?
I'm giving.
Give him. You are for the state.
My lord, I'm for the state.
So when did Mongola expire?
On 14th of May 2025, after filing of this appeal, she was died. In the meantime, the appellant was intended to file the stay application, but as she was died, the legal heirs of the appellant has filed the substitution petition to substitute their name in the name of the appellant.
My lord, the writ petition was dismissed on the ground of delay, my lord.
Very good. Substitution, why you are opposing?
No, I'm not opposing, my lord. My lord, only I'm saying the facts, my lord, that the writ petition was dismissed only on the ground of delay, my lord.
Only on the ground of delay.
Delay.
Order 81 MR.
Order to place corona. No.
81. No by 80 target case. Who is Shamol Bhattacharya?
His son. His son.
Then Shamol Bhattacharya, you have not made him a party in the substitution?
বিপ্রজিতা কাকুলি হচ্ছে মহাদেবের ছেলে
হ্যাঁ,
মহাদেবটা কি
মহাদেব হচ্ছে অ্যাপেলেন্টের হাজবেন্ড।
ছেলেটার হাজবেন্ড নয় দেখো যোগেশ্বর হাজবেন্ড
Who are these two persons?
They are actually the the Kakuli Bhattacharya, the appellant. Applicant.
Mongola was the appellant.
Yes.
Uh.
Here in the substitution application, the applicant number 2 is the niece of the appellant. And
What? Sir, Mongola had any son or daughter? Niece has to be substituted.
yes, Lordship, but
81, the person died. Mongola died thereafter. Give a copy to him. Give a copy of the substitution.
তারপরে জেরক্স করে
Come after 2 weeks.
দেওয়া আছে।
16th রেখে দেবে।
Deep
Check it
developed.
up, check it up.
My lord.
Yes, next. Next matter also you file substitution.
No, 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 lordship, but I am praying for time as a
16th করে দেবে। Yes, next item 5.
Deeply obliged.
এই সার্ভিসটা ফেরত দিয়ে দাও। Take back your service. Ascertain who are these heirs.
এটা নিয়ে আমি জয়চন্দ্র এনেছে
State should first class heirs, second class
করতে
heirs.
করতে
We will take it up along with the forwarders matter. We have keepten the forwarders matter in the list. ওইটা যখন forwardersটা ডাকবে তার সাথে। We will take it with the forwarders.
Yes, yes. 37. It will be taken up today or whenever it will be taken up.
Let it appear. If you have any problem, tell us.
No, 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 my lord. I am ready to do this.
If it is reached, we shall take it.
Yes, it is in the list. Then a list. Then
You don't want it today.
No, no, my lord. I am ready to do this at any point of time.
So very good. When we will.
Yes,
it is
item 34 for orders. My
আচ্ছা ওটা 34 ডাকলে দেবে যদি কোনো কারণে রিচ না করি পরের দিন ফরওয়ার্ডার সেই
Plan with the applicant, man.
I am appearing on behalf of state led by Mr. Pinaki Dhol, my lord.
Pursuant to your lordship's direction, my lord, I file a supplementary petition.
Lordship, Mr. Rai Mukherjee is appearing for the respondent number 4. I'm praying for a short passover.
let him start. Ask him to come. Where is the order impugned?
Memo of appeal, memo of appeal.
You have not annexed in the stay application?
I'm sorry, my lord. I have one copy, my lord. Another copy, I will hand it over, my lord, in the post.
পাগল নাকি? One copy in division with?
My lord, it is, sorry, my lord.
রাখো দেখি। Read petition was decided on affidavits. হ্যাঁ?
We have filed our affidavit, writ petition was
কি
decided.
হয়েছে বাবা? একটা বন্ধ কর।
ঠিক আছে বলে দিচ্ছি অর্ডারটা পড়ছে পড়ে নি
You file your paper book. This is final hearing.
The urgency is that my petition is terminated, my lord.
Pardon?
Petitioner is terminated from his service, my lord.
Yes.
This is the urgency.
File your paper book incorporating the pleadings. There is no scope for any interim order.
Yes, my lord.
There is no scope for
Hello.
that.
Lord, I am appearing for the respondent number 4 and 5, Poshimbango Somogro Shiksha Mission, my lord. This appeal was taken up by your lordship on 15th of August 2025, and I pointed it out that all the pleadings have not been placed before your lordship. So your lordship was pleased to direct my learned friend appearing for the appellant to file a supplementary affidavit.
Supplementary affidavit, I annex the affidavit in opposition and reply also, my lord.
Today
According
they
to
have,
lordship direction, my lord.
I have not received.
my lord, I have received just now, my lord. It is our opposition. Today I have received just now.
But there is no scope for any interim order, my lord.
Was not served.
I was not served, your lordship. I just got it now.
You have not served them.
I just serve it.
A supplementary evidence, you need not use any further pleadings.
No.
He will give
No.
you.
No, my lord, if your lordship direct my learned friend to file a informal or formal paper book, my lord, and fix this matter for hearing, my lord, it is a question of law involved in this writ petition, my lord, whether he was lawfully terminated or not.
So he has already brought on record the evidence exchanged by the.
Yes. Yes, on that basis also, my lord, your lordship can decide the appeal, my lord. Yes, my lord.
Now the post from which he was terminated has been filled up.
No, my lord. It is still vacant.
My lord, para teacher from 2010 onwards, there is an embargo, my lord.
There is
9th June 2010 onwards, my lord, there is an embargo, my lord, by the education department, my lord, school education department, government of West Bengal, not to fill up any post, my lord, in para teacher.
so on that ground you rejected his case.
No. On that ground, my lord, that is not the ground. My lord, the ground was that he participated in panchayat election. The circular says, my lord, those who participated in panchayat election and, my lord, held the office, my lord, for panchayat as a pradhan, my lord, he must tender his resignation because this para teacher has become a full-time job. Now, that is why, my lord, he violated the provisions of that circular, did not intimate it, no approval was obtained from the school education department. That is why it was terminated, my lord.
In the meantime, my lord, 2014 a GO issued and 2018 is also a GO issued, my lord. Once, my lord, kindly see the impugned order, my lord, that has been passed by the school education department.
You don't file serve in time. You have not yet got a copy of the supplementary evidence.
No, my lord. No, my lord. My affidavit, my lord, affidavit in opposition filed.
How can we accept one copy?
Hello.
After 2 weeks. Yes, next.
Grateful.
18th. 18th. Yes.
Well, kindly supplementary affidavit.
Supplementary ওকে ফেরত দিয়ে দাও।
Okay, দিয়ে দিল। Lord, matter will appear after 2 weeks.
18th.
18th.
Yes, next.
Grateful.
I'm deeply obliged.
My appeal, milad, there was a directions to file affidavit. There was direction for production of records also, milad. For production of records also, milad. I'm led by Mr. Bhattacharya, he is also appearing online.
Your Lordship, so pleased to direct me to file an affidavit, including all the records as well. So that I've done that in my affidavit in opposition. So this is ready.
All records are enclosed with the affidavit of the milad college. So milad, if your Lordship takes up milad, the affidavit of the college, milad, only 2 questions is involved.
Wait.
Mr. Bhattacharya is appearing online.
বলো বলো তুমি বলো
So what interim order you are seeking?
This can be disposed of based on this. That was a.
There's no scope for an interim order.
This can be
because
disposed of, lad, based on whatever
You
records
have to
available
hear
with
this
this
out.
affidavit, lad. Well, whether
Respondent eight opposition has been served.
yes, yes.
You have used any.
I need not. I need not.
matter only let's wait over that is 11 only 46
In short, lad, 2 points of law is involved, lad.
Yes, Mr. Bhattacharya.
Lad, may
No,
I
that-
pass, lad, so that means you can. But he's.
Bhattacharya, let the entirety be argued. You will submit half. Mr. Bhattacharya, this is not, he is much more senior to you. 16th.
My lord,
Call the next one.
Lordship is going to take it up on the 16th.
Let the affidavit in opposition
my
as filed by the respondent number 8 be kept on record. Mr. Shamim Learned Advocate appearing for the appellant submits that he
I'm led by Mr. Bhattacharya, lad. Mr. Bhattacharya is appearing.
Mr. Bhattacharya, you will not.
no we shall use and reply with that short reply in the meantime before 16th
Mr. Acharya Learned Advocate appearing for the respondent number 8 files the affidavit in opposition. Let the same be kept on record. Mr. Bhattacharya Learned Senior Advocate appearing for the appellant prays for leave to let the same be kept. A copy of the said affidavit in opposition has been handed over. Earlier you served. You served it at
No, yes, sir.
Mr. Bhattacharya Learned Senior Advocate appearing for the appellant prays for leave to file an affidavit in reply to the said opposition. Such prayer is considered and allowed. Let such affidavit in reply be filed within 2 weeks.
Lad, by this week I shall serve.
The matter for further consideration in the daily supplementary list of this court on 22nd September. Yes, next.
Leave it.
my lord, one indulgence.
Huh?
My lord, on the last occasion, our names were not recorded. We are from Vidyasagar University.
In which matter, sir?
This one, Taposh Mishra, item number 7. Item number 7. And copy of
This is
Tapos, Mr.
This is the-
You
the
appeared for
to the parent.
item number 7 এ অর্ডারটা হলো এক্ষুনি মিস্টার ভট্টাচার্য তো ওনার নামটা দিয়ে দিও
last occasion, 25,
হ্যাঁ
25th August.
দেখি ফাইলটা দাও
Nobody was there. After the university কেউ আসেনি. Sengupta was there.
Oh.
She was supposed to be there, but she was not there.
হ্যাঁ
On the last occasion, Mrs. Debjani Sengupta was supposed to be appearing. I don't remember as to whether, but your fellowship.
nobody appeared on your part
উনি ছিলেন তো।
আজকে দিয়েছেন
আর
উনি
ছিলেন না উনি
appearance.
সেদিনকে।
So you keep it today
সেদিনকে ছিলেন না।
your name will be there today you were there on the earlier occasion
My learned senior was there, I think.
please ascertain and make this
ছিলেন না
submission
বাবা, ছিলেন না, ছেড়ে দিন।
yes আমি facts Section 5 is there. কতদিনের?
87 days.
Where is the order impute, Mr. Acharya?
My lord, if you
Annexed to the stay application.
yes, my lord,
It's 44 of the established.
But yeah, give us 2 minutes.
one day short.
হ্যাঁ, এটা হয় আর
My lord, 31st I retired.
পলিসি ডিসিশন স্টেট বলে।
That's I can.
How
The
can
only
we?
thing, my lord, my submission.
You didn't say. Now give retrospective effect.
No, no, my lord, I know, my lord, what is fallen from you, but my submission, my lord, may not be palatable, my lord. Kindly appreciate 31st March 2024, I retired. Superannuity.
1st July থেকে effective.
And the circular was issued in April
In July.
2024.
In July with effect from 1st of April.
No,
কি করে?
effect given 1st April
এ আর কি করে?
2004.
ঠিকই বলেছে।
My lord, since, my lord, there is no scope for any pension, that is why, my lord, petitioner approached before your lordship. I know, my lord, the fate, my lord, it was.
Mr. Acharya, what can we do? What is the wrong in this order?
My lord, I dare to say anything about the wrong in this order, because it is absolutely a.
No, you could. Did you challenge the circular?
My lord, my lord, I was not there in the, it says, my lord, the petitioner is challenging the said memorandum on the ground that the fixing of cut-off date for implementation, my lord, 1st, 2nd, 3rd, 4th paragraph. That appears, my lord, this order.
Challenge করেছে। Cancel করে দিলে তো কি হবে? Cancel করে তাহলে তো কি হবেই না।
Now, Mr. Acharya, my brother has raised a very good question. That if we set aside the circular,
My lord, my lord, I should say, I should stop here.
you have all got the previous rate money.
Previous benefit has been given. My lord, since there was no scope for any pensionary benefit, that is why he approached this honorable court, my lord. This
It's a contractual engagement.
it is a one-time benefit has been given, my lord, the poor Sahayikas.
Where is that circular?
Page 19.
19.
19. In consonance with the finance department circular.
19 of the stay application.
Yes, ma'am.
Not the
Page 36. I said there is double pagination, so page 36. The original circular is of finance department. This is the circular of education department in consonance with that.
Next year P4.
That was issued on 7th March. Finance department.
7th March. 7th March 2024 for giving benefit from the financial year 2024-2025.
Where do we get it? Education department has issued in respect of such and such on attaining season. Now this in 7th March 2024, where is that financial year you're saying?
That is not written here, but in the original circular,
Do
that
you
is
have
there.
that original?
Present, that's not. That is not for this SSK, MSK, SSK, it's even for the academic supervisor, ASHA worker, Anganwadi worker, all sets of this engagement, contractual engagement who are allowed to continue either till 60 years of age or 65 years of age. For them, this enhancement was done. Initially, for the people who was retiring at the age of 60, they were getting 3 lakhs. Who are returning at the age of 65, they were getting 2 lakhs. Now this has been merged and say both of them, if they retired after 1st of April, they will get 5 lakhs instead of 2 or 3. Now, my lord, unfortunately, he retired on 31st of March 2024.
No, Mr. Jahan, we are wanting to see
The original
that
circular.
Finance Department circular, as you said, that it is to be from
Kindly
the
fix any day, my lord, you shall produce. Even tomorrow.
because just explain it to us because page 36 governor has been pleased to fix the date.
Yes, yes.
Yeah, it is an executive instruction on the name of the governor.
Yes.
So that must be that it is 7th March must be for the financial year.
24-25.
Must be so.
Yes, yes. I shall produce that original copy. The copy of that March 2024. And burden on the shoulder of the appellant.
Now, my lord, the 7th March 2024, it was a, my lord, this,
Have you made that pleading, Mr.? Is there any statement to the effect in your writ petition that 7th March 24 was the finance circular, which specified a date prior to the date of your retirement in respect of all the classes of employees mentioned in that? Is that a case made out? That is also not a case made out.
23 onwards, the grounds.
সেটাও প্রডিউস করতে পারে said that the memorandum is arbitrary.
no, my lord, so far as the 7th March 2024, there is no pleading. This was done, my lord, only 9 paragraphs, my lord, writ petition has been draft, very slipshod
So
manner.
Mr. Jahan, you bring that. So the records reveal that the আমি ভাবলাম ওটা ঠিক আছে এই পুরো ডিফারেন্স পাবে ফাইল অপোজিশন ফাইল
My lord, it is being affirmed.
My lord, I am for the petitioner, my lord, appearing online, my lord. Opposition not yet been solved, my lord.
Just
As on date.
please accommodation. Take it up tomorrow. Kindly take it up tomorrow. Today it is being affirmed.
My lord, we were given a chance to file our reply also. Then, my lord, if it is solved today.
Filing the opposition.
My lord, it is being affirmed today. I will give a copy to my learned friend in course of today, and tomorrow when the matter is taken up.
No, he has to use a reply, na? That was our.
And then let it be day after tomorrow.
একদিনে কি reply?
He has to file a reply.
No, he is claiming urgency.
Yes, but you've delayed. He has to file the reply,
Yes.
Dr. Patro.
No, the last extension was 2 days for me and 1 day for my learned friend.
That also you failed.
My lord, that I have.
10th September রেখে দাও. Give the copy tomorrow.
Very well, very well.
My lord, deeply obliged.
Yes.
I am for the appellant. Last occasion, your lordships. An application regarding my lord, amendment of cost title was not available last occasion. That is why the matter was getting adjournment. So now
I need to appear for the school.
Now, my lord, I have served everybody.
You have filed any further application?
Check
removed.
A amendment of cost title, your lordships.
That you have done.
Yes, my lord. That is
Where
can
is that?
can 2. That is can 2, my lord.
You could have, for that you have filed an application.
Lordship, I made an application on the ground that that during pendency of this, my lord, proceedings, the board has taken drastic action against me, or getting compulsory retirement already given.
Where is the order in claim?
My lord, that is in my
7 and
can 1 application. Can 1 is the ST application.
your service is complete upon everybody.
Yes, yes, lord. This is the evidence service, my lord.
Very. Now, which page? Stay application, your
Board
Stay
should appear,
application,
my
my
lord,
lord.
West Bengal Board of Secondary Education. If applicable means served, they will be along with the school, my lord, they will be the answering party because that disciplinary action has been taken by the
258.
by way of disciplinary proceeding by the board. That has been challenged, the suspension by the board. That has culminated into the final order of the board. The entire, my lord, cause of action of the writ has been, my lord, has now gone, my lord. The board has taken his final decision.
No, during pendency of this matter, my lord.
no,
But what happened, my lord?
respondent 8
that-
and 9, who are there?
8 and 9 as the school and the managing committee. But
School and the managing committee.
but the situation is this, my lord, administrator is running. Administrator is working.
Very good. You have
Already have a administrator. I made a party at the very.
administrator was a party in your
Yes.
writ petition.
Yes.
And that is respondent number, which respondent in the present appeal?
8 and 9, my lord. That,
7. Achha.
that is in the writ petition.
Very good.
That
Now,
was not
school,
included in that.
have you served upon the
Yes,
school?
my
Achha.
Impugn order is 258 page of the stay application.
Page 58.
What is then 255? He earlier approached.
255 is the order of the division bench, coordinated bench of our High Court.
You earlier
Already that this chapter already covered by the division bench. But division bench, my lord, observed that that if any, my lord, I mean, kindly go through page 256. That is a
No, what are you saying, Mr.? This cannot be hard in.
My lord, kindly, my lord, this 258 is the impugn.
That, what did you say? That
Oh,
this,
board has come. Now,
so now board has come.
board has
Acha, let us ask.
My lord, only my lord, one
We
subject.
will please let him.
No, regarding this CAN 2 filed by him, where amendment has been made. My lord, CAN 2. My lord, why this CAN 2 appeared? Why amendment made? Let it kindly come to page 255, the order of the coordinate page.
No, he wants to add the school.
No, I am not on that. At the school is a separate aspect. I am not on that. Here, my lord, what was my submission before the learned single bench? That, my lord.
We are not on that. There was a defect pointed out that some of the respondents have not been included. In the writ petition, school was a party.
yes, my lord.
Those are the persons whom you want to incorporate.
Yes.
Yes. Now come to the main matter. What is it?
Actually, my lord, I have challenged you.
All right. Give us 2 minutes time. Let us go through the order.
Yes. Main matter is, my lord, suspension of illegal, revocation of illegal suspension.
Now, where is the order impugned in the present appeal?
That is.
This is the order.
258. This is the impugner. Repetition annex.
Don't disturb me.
Don't disturb.
আপনি কোনো কথা বলবেন না। I like to talk with you. I am reluctant to talk with you.
I don't like to talk.
যা বলার যথার্থ বলবেন।
Tennis করে নিল। পুজোর আগে পারবো কিনা জানি না।
So, why you are challenging this order?
My lord, I am challenging this order, my lord, because there is no such subsequent development. Subsequent development is.
Come to the order.
Yes.
Paragraph 3 of the order.
That is the my lord allegation, because I do not admit that. That is why I have come before your lordships.
So go to the single judge, say that you have not conquered. Go and tell the single judge that you have recorded.
I have repeatedly submitted, because my lord, what have things is this.
Mr. Ahmed, you should approach the person before whom you appeared.
I'm agreed by this.
I did not conquer.
By this paragraph also, my lord.
No, Mr. Ahmed, you are saying I did not conquer. Court recorded I conquered.
Yes, ma'am.
So then you are alleging an infirmity in the recording. So whom should you go? You should go back to the single judge and ask for a clarification.
No,
moreover, what is the wrong in this?
But my lord, there is no subsequent development is concerned. My lord. I do not participate in their hearing because
তারা বলেছে যে it could be open for the petition to amend the with the subsequent development. এই একটা তো সুপ্রিম কোর্ট নেই।
হ্যাঁ
অর্ডারের ভিত্তিতে
পিটিশনের নেই
বলেছে আমি একটা সাপ্লিমেন্টারি অ্যাফিডেভিট ফাইল করতে চাই।
আমার সঙ্গে আমি একাই আছি
Notwithstanding the court that submission to come in short. বলছেন আমি করতে চাই না।
বিবেক আছে বিবেককে দিয়ে দিন নাম বিবেককে আমি এতে রেখে এসেছি
So what do you want from us?
sir, my lord, I want this, my lord, kindly, my lord. So already that chapter already heard before the coordinate bench of our High Court, division bench or High Court, that from the very beginning, my lord, there is a total breach of natural justice, my lord, because I do not get any opportunity for give reply of the so cause. In a so cause issued on 22nd of January 2024, and I got it in the first.
What do you want from us? What do you want from us?
I actually not come here to ascertain.
Don't file the supplementary affidavit. Now that single judge has said subsequent facts which need to be brought on record, you file a supplementary affidavit. Matter has not
I
been
don't have any
disposed-
opportunity to file supplementary because
Don't file. Hear out the matter.
because the matter is
Don't file it. If there is no subsequent fact which you want to bring on record, don't file it. Hear, and ask the learned judge. I mean, he will hear out the matter on merits. This is a leave granted to you.
yes.
It's not a compulsion.
Yes.
It's a leave granted to you. If you don't have subsequent facts, don't file. Proceed with the hearing.
But situation is this, my lord, one thing kindly. In the meantime, when the matter is pending, in the meantime, my lord, compulsory retirement has been given to me.
So you have to challenge this.
That you have to challenge. That's beyond the scope of the writ petition.
Unless you challenge
course,
the
my lord.
compulsory retirement today,
Yes.
what relief you will get? You have to go back to the single judge.
Grateful, lord.
And before the single judge, as my brother points out, that if your contention is there had been no subsequent facts, my submission has been erroneously recorded, there is no requirement for any supplementary evidence, then don't file it. Don't file it. Make a prayer that I don't want to file supplementary. Hear out the writ petition, finished. Then why do you want a dismissal order against you? We have to dismiss the appeal.
No, because this is a line of alignment.
Madam, may I
Why
say
I'm
one thing?
No,
I'm
Why this
the
subsequent
line of
Madam,
alignment.
wait. Where is the order of 14th
There is,
February
my lord, already, my lord, there is a
October
guideline.
14th October.
against which the previous appeal was preferred?
14th October?
5 এর
না না 250
এই 255 এর রিটের
My lord, guideline already given by the Honorable Division Bench. So
না দেয়নি
দিয়েছেন না
not
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 annexed.
part of this
not part of
record.
Writ petition to file.
The next one.
দেখো তো
এটা তো পড়েছে। Writ petition you have not annexed?
my lord, writ petition I do not annex. If the heavy writ petition, my lord, it will
well prayer in the writ petition was not challenging the suspension order.
Because that happened subsequently.
Yes, so my lord, this
Actually,
he is directed to file a supplementary affidavit.
he has to challenge that suspension if at all, if he's aggrieved.
He has not challenged.
not
Number
challenged.
one, number two, he has not challenged the charge sheet. He has done nothing.
I have challenged the illegal suspension order.
That not in
That
this
is in the writ petition. That is the writ petition.
That
Yes. Only one copy is here.
well, Learned Single is directed to file a supplementary affidavit regarding those subsequent development after filing of the writ petition.
Page 353 is a suspension, order of suspension. That I have challenged.
এই নাম্বার কত?
Yes.
কোনটা দেখাচ্ছি? না না এটা সেটা আপনি নাম্বার নয়। আচ্ছা
এটা করছে শুধু টাকা
353. Read petition was affirmed on
Prayer. My lord,
12th September
Yes.
23.
44.
Now suspension order was
353 page.
এটা হচ্ছে
353.
পিটিশনটা আনিয়েছি। প্রেয়ার হচ্ছে যে ট্রান্সফার দ্য অ্যালিজ টিচিং।
Well, the writ petition, which is what
just the letter.
prayer. This prayer is different.
Prayer page 44, my for once.
353 my page.
What was his prayer and what he is seeking in that?
353 is not an order of
The suspension that I have challenged.
Not in this writ petition.
Not yet.
That has not, this is not under challenge.
353.
Writ petition number to
Yes, ma'am.
353. There is no such order. This is a writ petition 14474.
Yes.
Yes.
14474. My lord, come look at prayer of this writ petition 14474.
Order of suspension. Order of suspension is this is also.
Acha, what is the date of the order of suspension?
My lord, suspension order is that I have enclosed here in page 189 of this appeal.
2024. Order of suspension is 30th January 2024.
Page?
Page, well, in this, my lord, that is the page, my lord, 189. In this appeal.
One.
January.
That is subsequent to the writ petition.
Yes.
Suspension you challenge. Now, single judge passed an order which we do not know, against which you preferred an appeal. 14th October 2024, single judge passed an order. That is after the suspension order was issued.
কত পড়লি কেন?
189 এটাই তো।
এই যে
189.
কোর্ট বলেছিল শুধু ইয়ে করবে।
Ad hoc Committee of West Bengal Board of Secondary Education in exercise of provision as per Rule 6 C of the West Bengal Board of Secondary Education, Confirmation, Conduct, Discipline, Teacher and Non-Teaching Staff, Rules 2018. By notification number suggestions are dated
All right.
18th to 18.
Everything
Hereby
is
suspend.
right.
But actually, my lord, a audit report and commission report says there is no defalcation of fund, no defalcation of money is involved.
অফিসটা চেঞ্জ হয়ে গেল।
Yes, ma'am.
কিচ্ছু করবে কি করবে? But you are it has gone in your favor. Division bench said that you file an amendment application.
Yes, that is
Single judge says
fine.
that not required. You bring those on record, I will decide
That's
the
already filed, my lord, but that was not considered. That is already filed.
amendment application
Yes,
filed.
yes. Can 3.
In which matter? In the writ
This
petition?
writ petition.
That I was showing, amendment
In writ petition, my lord.
challenge the subsequent development of charge sheet or final orders. In amendment application, he said, suspense, challenge the suspense. Thereafter all,
Amendment is something different, my lord. Amendment.
that part is over.
Over.
Finally,
No.
see the order of the
No,
division
madam.
We have only said that there are several documents which have come into effect after the writ petition was filed. The single judge has granted you leave to file a supplementary affidavit. This order does not prejudice you in any manner. And as such, we have said no interference is called for, and we have dismissed the appeal.
Yes, grateful. Extremely good.
Yes, next.
I pay for the University of Calcutta. I'm yet to receive a copy, my lord.
Lordship, I am for the appellant.
You have not given copy.
Served, Lordship.
Why is it
Chancellor.
defective, madam?
They have served the chancellor.
Lordship, I am served this
They have
for
not-
the chancellor.
2024.
अरे chancellor के service के लिए है ना madam.
You have not removed the defect. You have seen what is the defect.
Lordship,
On 31st July 2024, leave was granted to cure the defects, my lord.
Now what happened? You
Lordship, may I
want a
submit?
copy?
But I have not received it.
Lordship, I will serve then.
Huh? What is compulsion amendment?
Lordship, may I submit the factual metric first?
Yes.
Lordship, in the year 2023, the appellant being aggrieved by the decisions of the respondent number 5 and 6 of the college, that is under the University of Calcutta, Shama Prasad College, he was working as an assistant of the assistant accountant. In that post, he was held, and Lordship, while holding on that post, he was holding a multiple positions of that particular university under the same salary in a different building. Lordship, please come to page number.
Yeah, just a moment.
30, Lordship.
You were posted as a
Lordship, in page number 29, my appointment letter was first given, and it was stated that Lordship,
page 29.
9 Lordship of my application.
You're appointed in 2019.
In 2000 Lordship,
12.
On 18th
You were appointed as whole-time assistant to accountant on
probation period.
Now you are getting regular salary.
Lordship,
Salaried staff of the college.
Lordship,
You are a contractual engaged.
Lordship, I was engaged permanently in that college. Why I'm saying so, Lordship, page number.
Then where is your approval of service?
Lordship, my approval of service is page number 30.
30.
Just next page, Lordship, where it was stated that I have been pleasure to inform you that the governing body in the meeting on 19th 12 2013 has confirmed your service with effect from 25th July 2012.
Then page
Now, Lordship,
31, you were confirmed in service as what?
Lordship, after that, holding that post, additional post I have holding
Assistant
in
to an
librarian,
Very good.
accountant.
Assistant to an accountant. Then you were sent to a library.
Lordship,
So you no longer worked as assistant to the accountant.
Lordship, yes. Why I'm saying so? Now, after coming to page number 31, Lordship, come to page number 32, where
additional duty
was given in the second paragraph. Lordship will be that apart from this responsibility of assistant to the library and day section, you are also assigned to the above duty. So, Lordship, I am holding a lot of position in this college under the same position, but without holding any post.
How much you are getting?
Lordship, 12,000 was there in the first. In the first appointment letter, it was clearly stated 2,000 rupees will be given on a monthly salary basis. Now, Lordship, what happened? I am.
So you are getting 14,000.
Lordship, right now I am getting little bit more than 12,000. Lordship, little bit more. Lordship, I just want Lordship to say that
want more money. That I am doing extra work, you give me some more money. That is your
Lordship, that is one. And Lordship, if my post is not clearly stated right now in the dignitary post, it was vacant because the proceeding is going on, so there is no position is allotted to me.
Means?
This since this appeal is pending, this appeal is filed. I have filed.
Is for the college. For the
But I am appearing on behalf of the
approved staff or not?
What is the contractual casual staff?
Contractual casual staff. So Mr. Panda, give him something more.
No, that is not the intention of the petitioner.
Accountant, he was working as assistant to the accountant. He was working then in library as an assistant to the librarian.
But only for kindly see the intention of the petitioners to file a appeal. My lord, kindly see the appointment letter. My lord, this is a intent. My lord, the college authority has, my lord, giving a, my lord, the casual employment to the, my lord, the.
Where do we find that casual appointment?
My lord, that's
you are saying you have confirmed him in service. 25th July 2012, page 30.
My lord, this is also, my lord, only for the contractual post. He is not the, my lord, the regular staff. He had this post has been.
So was his appointment. So was his terms of appointment.
Not the terms of appointment.
If he's a contractual engagee, there has to be a terms of appointment.
Yes, yes.
Where is that?
Well, I have I have to bring the all documents. But it is the fact that if the college authority has not giving appointment to the particular sanction post, because of then I have to make the advertisement. We shall call for the candidates advertisement, and we have conducted all the proceedings. That has not been done.
File your affidavit explaining that.
Lord,
That is a contractual.
Yes, yes, my lord, I shall. And not only that, my lord,
now you are working where?
Lordship, I'm working right now as assistant of librarians. In library sections, I'm working, and as well as in the laboratory section, Lordship.
Are you doing the additional duty?
Lordship, please kindly consider page number 39 of my application. 39 of my application. Lordship, will find that after holding a lot of posts without having any position in the college, I'm aggrieved by that, and I filed an representation to the college that please consider my positions, otherwise I am hampering.
What did you say? Let us.
Is a reasoned order from this college side, Lordship, and my application is just period to it. But it's page number 33.
নাম্বারটা এখানে ইনক্লুড অর্ডার থেকে নিয়ে না
পলিটিক্যাল
সেটাই বলেছে তাই বলেছে Political.
ইনক্লুড অর্ডার করবো তো
লিগাল রাইট তো নেই হচ্ছে কোনো চেয়ার দেয়নি কিছু দেয়নি আমি বুঝতে পারছি না। এইসব কিন্তু টোটাল I mean, it is not against Trump. And he has transfer strictly.
Lordship.
Madam, you have to survive. How long will you fight against these persons who are maybe politically your allegations have been made?
Lordship.
But that is your source of life and livelihood. Whatever you're getting today, tomorrow the governing body can adopt a resolution and throw you out of the college. Then where will you go? So,
Yes, Lordship.
so the employer has to be taken in confidence. You can tell them, sir, you are sending me to so many places. Please consider whether will you give me 10 rupees more or not.
Lordship. After serving this representation, Lordship, please come to page number 39. Lordship will astonize that in the
absolutely
Lordship will astonize page number 39, the last paragraph they are saying that it is also advised that the baseless derogatory representations are not to be made in near future to maintain the decorum of the institution. So, Lordship, my question is, if the decorum institution is like that and putting my position in a multiple position, having not sanguine any post,
So don't
what
do the
Lordship?
additional work then. We will say you will not be allotted additional.
Lordship, what Lordship pleases, Lordship?
Don't want to do additional work.
Lordship, I will. Lordship, the salary will speak on that. Lordship, my post, my hold, everything, increment.
Show us that you are an
Lordship.
approved staff. You are not an approved staff. You are a
Lordship.
contractual engaged.
Lordship, I will
Sad
come
that you are
instruction, Lordship.
continuing from 2012 as a contractual employee. So what you can maximum get is you can request the college that give me something more. That
Lordship,
is what
please.
we are asking Mr. Panda to do. He is a good person.
Lordship.
after
Mr.
5
Panda is a good person. He will do it for you. Huh?
my lord, I advise to the principal that you just my lord, adjust with the petition appellant. But the appellant is my lord, my lord, arrogant.
No, no,
He is one by one, my lord, kindly see one.
We will say so. If he is arrogant, he will become humble. You tell us how much more you will give him.
Well,
Admittedly, he is doing so much of work.
my lord, every contractual employee, whatever amount has been given, my lord, we have also given to my lord.
No, we are not saying. This is an admitted fact that he is an assistant to the accountant. Next, he has gone to the library. Now you are saying that due to scarcity of stuff, you do this additional work also.
My lord, he has not given any additional work. Only don't go by the language. My lord, we have just shifted one building to another building. My lord, this is because my lord, this is allotment of what my lord, the work. Not my lord, we have given any additional work.
Lordship, at
My lord,
present, I am
do not,
holding
my lord, go
multiple.
with the language.
If no additional work is given, how you are issuing this letter?
My lord,
Page
kindly see, my lord.
Page 32.
My lord, before that, my lord, page 30. Then kindly, my lord, page 30. No, my lord, page 32. Page 32. My lord, kindly see, you are hereby to additional duty. additional duty means the normal duty to, my lord, shifted in another building.
Acha, you will explain what is additional duty.
My lord, I can.
Your principal will say additional. You will try to interpret it is that it is not
No,
additional.
kindly see, sir, that was not their intention.
Your principal is so adamant, then we know how to deal with your principal.
My principal is not adamant.
You are saying you consider, you take the court's advice, you talk with your client. That
Then I shall come back before your lordship, my lord. What, my lord, amount?
Lordship, along with that,
Then
I
shall come
rely
back
on
before your
some
lordship.
judgment, Lordship. Lordship pleases, I will submit, Lordship.
do you want to do additional duty or not?
Lordship,
You go on fighting with the college or come to a settlement? Tell us.
Lordship with instruction, Lordship. Next day, I will file my judgment. I am relying on some judgment. Along with that, Lordship, I mean instructions. Lordship, kindly, Lordship.
Also, the present appeal has been preferred, challenging an order dated
But I beg to appear on behalf of the read petitioner appellant.
There is a direction upon me to take instruction, my lord. But I sought for instruction. I will get it today or tomorrow. My lord. Can you adjourn for 2 or 3 days, my lord?
what type of instruction, Mr.
From the office of the DI.
What sort of instruction? The compassionate appointment?
No.
No, my lord.
Lord, family pension.
CPF to GPF
CPF
conversion,
to
my lord.
GPF, it has already been decided by the Honorable Court.
Where is that? Which, that 13 June circular?
13 June circular, on the basis of that, Honorable Division Bench, Lord, the Honorable Single
That
Judge
was
First
for
Order.
the employee concern.
Employee concern.
Where is that circular of for extension for widow?
Lord, the order is there. I have annexed with the order.
কোথায় অর্ডারটা কোথায়?
Lord, that is there in the at page.
অভিজিৎ বৈদ্য?
No.
Abhijit Bodro, no? By
Not Abhijit
considering
Bodro.
the Abhijit Bodro, my lord, this Honorable Court passed an order.
শেফালি জানা?
Now, this is
শেফালি জানা?
Yes.
But Shefali Jana was where is that modification application made between Obijit Boiddo? Then what happened? 3 months time was initially extended in terms of the Obijit
Yes,
Boiddo citing ROPA
Yes.
that all the employees
Their only employees are there.
thereafter the widows came.
The widows came. So far my knowledge is concerned, the order passed by the Honorable Court, this has been decided by this matter and other 2-3 matters I have got.
Mr. Bari, you show us that.
Here the employee concerned died in 2007.
Maybe. Please find out that unless anyway I have also fixed another matter to cover raklam. So you when can you come with that instruction?
Next week,
Then put in a short evidence. Let us decide.
Perhaps let me take the instruction. If necessary, then I shall file affidavit. Only not this week,
Thursday.
Next
Thursday.
Your Lordship.
Very good, madam.
Grateful to you.
Thursday week. Thursday week.
This matter I am appearing for the appellant's petition. On last occasion, your lordships directed me to serve again a test copy to the respective landed actor. On the basis of that, I am filing the affidavit of service. Mr. Gaurav Das is appearing for the Primary School Council South Chowbis Pergana, and Mr.
Oh,
is appearing for
Gaurav Das has not come, we were told.
but they have received by hand.
They have
Respective
received.
lodges. Finally, see the
What is the matter about?
matter about the organized teacher. On the last occasion, this matter have moved in the year of 1940 before the Honorable Justice Ashok Daswazekar. And the Honorable Justice Ashok Daswazekar was pleased to pass order in favor of us. Then
Regularization.
Regularization. Non-compliance of the order, we made an contempt application. After that, my lord, on the basis on the contempt application, learned advocate who was appearing for the state, he has submitted that is the on the same issue, this pending before the Honorable Supreme Court. And contempt has been dropped, and Honorable Justice Ashok Daswazekar has directed me to file an addition of party before the Honorable Apex Court. On the basis of that, I file an application for addition of party before the Honorable Apex Court. Apex Court was observed that this application has already been disposed of, so it is not necessary. You can file afresh before the Honorable Court, having jurisdiction. On the basis of that, I have filed this application before the Honorable Justice Partho Sarathy Sen. And this Honorable Justice Sen was pleased to pass an order. Principal Secretary was considered the representation in accordance with law. Against that, my lord, we file an application before this Honorable Court. And we moved this application before the Honorable Justice Amrita Sinha. And Justice Sinha, order was passed, my lord, was pleased to pass an order. That is, the Navaporjay has already settled in the Supreme Court. So I could not interfere. This application is dismissed. Against that order, I came before your lordship.
Now, Justice Sinha said, what has been decided?
Navaporjay Somiti, my lord, kindly see the order. I am reading the order.
So the writ petition was on affidavits?
No affidavits.
So you file your affidavit, there is no scope for any final.
Yes. No scope for any order, my lord.
Out of annex the Supreme Honorable Apex Court's order.
Uh-huh.
Honorable Apex Court's order.
Annexed.
Annexed. I have annexed. I have not published anything. I have already all orders I have annexed.
My lord, I am appearing for District Primary School Council. My lord, I am appearing for the District Primary School Council South 24 Pargana. My lord, today my health is not okay. My lord, I am not able to come to court. And can it be taken up tomorrow if your lordship's list permits?
No, can this be decided without affidavits?
My lord, that point has been already been decided by the Honorable Supreme Court. The
Oh.
point of organizer teacher has been already be settled by the Honorable Supreme Court.
No, we were told another coordinate bench has delivered a judgment that Monindranath Sinha was considered by the Supreme Court, and on the basis of that, Justice Tandon passed an order.
My lord, recent judgment on the point of organizer teacher is Niranjan Sahu. Considering all the aspects, my lord, the Niranjan Sahu was assailed before the Honorable Supreme Court, and the Honorable Supreme Court affirmed the order of the Niranjan Sahu. But Niranjan Sahu, on the point of that whether his name is featured in the DLIT report, and upon that DLIT report, my lord, subsequently steps has been taken. But that the issue of primary school teachers has been already been settled by the Honorable Supreme Court by constituting a committee where from all the organizer teacher working in the various districts has to be enrolled their name, and after verification by the committee, their name has been recommended, and thereafter the matter has been settled. After the point being settled up and the committee being become defunct, my lord, it cannot be reopened by the way of a fresh read petition.
So that was told by Miss Sinha.
Yes, my lord, if your lordship kindly gone through the order of the principal secretary, all points from point number 1 to last point has been settled by the principal secretary.
We have not met the party before the Supreme Court or before the Honorable High Court. This is the first application before the Honorable High Court in the year of 2014.
সুপ্রিম কোর্ট অর্ডারটা কোথায়? সুপ্রিম কোর্ট অর্ডারটা কত?
Supreme Court order to annex করেছে, তুমি দেখো।
All right, let him come in his presence, we will get. If it is decided, then we will dispose it of fine.
We have not come before the Honorable Supreme Court or Honorable High Court matter. This is the
Maybe,
separate
if
issue, but
the point is settled by the Supreme
Yes.
Court, what further order can we pass, Mr. Mukherjee? Let him come and make his submission
on next week, my lord.
next Thursday week. Mr. Das, you also produce before, when you come back, you show us that after Obhijit Boiddo, there was a modification application moved.
Or my lord, the file and affidavit
by the widow
to enclose the all documents.
My lord, it is a point of my lord organizer teacher. My Obhijit Boiddo is CPF to GPF.
File affidavit.
Obhijit Boiddo, not in this one. I'm asking you another.
My lord.
Tomorrow, Thursday week.
And if it was service is kept on record, my lord. I have served already. And
Then let it be before, after the vacation.
Whatever your lordship.
Mr. Das,
and in the meantime,
we are keeping it after vacation. If you want, you ask.
Yes.
Well,
okay, online appear kuch bole debe for DPS. Video service.
On the last occasion, the DPSC North has been recorded, but I appear for DPSC South.
তাহলে উপরে লেখো by reason of a typographical error. The name of Mr. Gaurav Das was name of Mr. Gaurav Das, the learned advocate, was recorded as appearing for DPSC quote unquote North 24 Parganas in place and stead of South 24 Parganas.
South 24.
Office is directed to effect necessary correction. Stop. You have annexed all the affidavits to the...
Yes, all the affidavits and press copy to my learned friend and also...
The present appeal has been preferred, challenging an order dated. Third September 2024, passed by the learned single judge in the writ petition being WPA 8442 of 2024. Heard the learned advocates appearing for the upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are of the opinion that there is no scope towards issuance of any interim order. However, the appeal needs to be heard finally. We have been informed by the learned advocates that all the pleadings and documents exchanged by the parties before the learned single judge have already been annexed to the present stay application. In view thereof, list the matter for final hearing.
Yes.
In the combined monthly list of November 2020.
As per orders, my lord. As per orders.
List the matter for final hearing. In the combined monthly list of November 2024. After let it appear, you mentioned we will
Yes,
put
yes.
it in the supplementary letter.
Yes.
Mr. Das, we are asking for that in Obijit Boyddo's case, there was, after that, there was a modification application moved by the widows.
My lord.
So after Obijit Boyddo, government issued a circular of 13 June.
My lord.
After that, the widows applied for modification.
My lord.
It was modified.
My
And
lord.
a government order was issued giving chance to the widows to apply. So far as, please check up that, and if you get those circulars and the order, then please come and give us a similar matter. Yes. Yes, Mr.
Next matter now also.
Our next matter.
This is another matter, not same matter. It is the compassionate apartment. As such, my learned friend is appearing for.
I am both the state respondent.
Why defective?
Rejecting, my lord, the only on the ground, the 47 days shortfall.
Delay.
47 days, my lord. 47 days shortfall by way of attending the majority 18 years. That's why, my lord, this application is rejected. My honorable trial judge.
Delay in, what is the defect in the appeal?
Oh, effect of the appeal, my lord, kindly, the order passed by the honorable justice.
Defect. There's a defect. Stamp reporter says there's a defect.
Oh, stamp report.
Key defect ta key?
Delay আছে নিশ্চয়. There must be some delay.
জানি না কতদিন
classified in what? যেটা লেখে।
Joseph side দেখছি।
Which order have you challenged? Page 27 June.
It's passed by the honorable justice Prayasakhar Manta, my lord, this order.
2009 মারা গেছে।
It starts from page, my lord, 72, must stay application.
7.3. 7.3.
Page 7 stay application.
Second page of the order missing আছে। orderটা আছে। হ্যাঁ, পরের পাতাটা দেখো 1 2 3 4 প্যারাগ্রাফ 8 থেকে 2
Oh,
সবকটাতেই তাই আছে।
you missed one paragraph.
One page. Page number 2 of the order is missing.
Yes, specifically 47 days shortfall for attending the majority 18 years.
Page number 2 টা missing.
72.
72.
Come to the next page.
Oh,
Internal
73.
আরে 72 73 না ইন্টারনাল পেজ 2 সেকেন্ড পেজটা কোথায় অর্ডারে
এক সেকেন্ড
মেমোতেও নেই
মেমো চলবে না
Mr. Mukherjee,
yes
even in the memo the second page is missing.
yes so far
yes missing
Yes, it's not there anywhere.
yes my lord I stand correct my lord I tender my apology
It's all right,
for
but where is the page?
দেখিস না কেন পেজগুলো ঠিক দেখিস না কেন সেকেন্ড পেজটা নেই কিছু নেই এ করিস না my lord may I tender my apology my lord
না না সে ঠিক আছে ইউ গিভ আ ফ্রেশ কপি
yes obviously
নাও হোয়াট ইজ দিস ম্যাটার you could not attend majority within 2 years from the date of death.
Yes.
That is the case.
Yes.
So Piyali Saha to time to extend করে
Piyali Saha,
Piyali
Yes,
Saha
that-
covers
that is the rigid, but 47 days, my humble submission before your lordships, that is the round figure, only 47 days. Not for 1 year or not for 6 months, 47 days is around 18 years.
What is your qualification now?
High secondary pass.
আর তো তার তো চাকরি পাবেনই না
For group D post, we cannot claim as a group C or officer's rank or group A. This
But
is
how
the
will he condone?
mandatory provision for group D
আচ্ছা
post.
how will we condone? We are bound by Piyali Saha.
Piyali Saha rigid, that is that I have
But
read
how
the
can we
judgment, that
help?
is the, but 47, where here is the.
Show us any instance, show us that it has
My
been
lord,
done.
I
What
annexed
this
the-
order you have annexed of
Yes,
just
I annexed the concurrent coordinate
Huh.
judgment. Kindly see last annex in my application. Page, it starts from page
এরম ভাবে চলে 48 দিনের ডিলে
77.
You are the son.
Yes, and
Eh?
it's a third round litigation, mal.
Father died.
My father died in 2009. 15, 16 years have already passed. সে পড়ে নিচ্ছে দেখে নিচ্ছে সময় নিজে দেখবে এগুলো দোষালিটা আমার এগুলো
বলছি না দিব
ইমপ্রেশনটা খারাপ হয়ে যাচ্ছে ওটা জাজেস কপি সেকেন্ড জাজেস কপি কিন্তু করোনা লেটার
ইমিডিয়েট নিড আছে বলে So what judgment you have annexed?
I have judgment the coordinate page 77 Honorable Division Bench. Before this court, my lord, the Honorable Justice
Division
Devangshu
bench,
Bosak and the Honorable Justice Sabbar Rasidi.
what has been stated?
Stated, my lord, this is the delay point that for last they are waiting for, that is the observation made in this.
This was a primary teacher.
My lord, this is
This coordinate bench judgment was in primary teacher.
no. This is the
State-
coordinate
state
bench
government
related to constable.
Mr. Mukherjee, there is no provision.
Yes.
If there is any provision, we can do. Earlier round litigation, REET court said that this 47 days, 57 days delay, you cannot just throw it away. You have to consider a deserving case in the appropriate year.
Yes. That's right.
So that the principal secretary considered and said, my hands are tied. Unless the scheme is changed, how can we give you?
A statute specified.
To show us any judgment, there
So, my lord,
is no judgment without the scheme. If there is no scheme, it cannot be done, Mr. Mukherjee. How can we help you? Give us something, show us any judgment on that, we will pass on.
My lord, I shall take, give time, my lord, to show I shall try as my best level to.
কোথায় time নেবে? The person will be under belief that High Court is insisting something will happen to me. This is unfortunate.
Yes, ma'am. This is the larger bench decision, my lord. I have seen, my lord.
Then,
This is the larger bench decision.
if you have any possibility, we also
Right.
do not want to dismiss unless we get any material. What can we do? Tell us.
Rightly so. As your lord says.
Adjournment will not help you.
As your lord says.
Acha, that coordinate bench judgment, anything you want to show us? Oh, dismiss করেছে?
If I know present, we'll ask.
Debargo, that it has been decided. এটা ওই মলয়ানন্দ সেটি টেটি সব দেখেছে। এইটা ওই দেবার্গ চক্রবর্তী যেটা বলছে না, এটাই ওই দীপঙ্করের যতদূর আমার মনে হচ্ছে। ওই সাইয়েদ হোসেন।
আমাকে এটা বুঝছো না কেন? 18 বছর হতো এই পয়েন্টের ওপরে, তাহলে সে ফালতু কথা বলছো কেন? প্রশ্ন করছে একটু যায় করতে পারবো consider.
So why you have annexed this? This order is also against you.
That is junior as a coordinated bench, that is in respect of same that things. So I do not find any same thing. That is the statute is there.
Acha, where is show us the order of the secretary in the previous litigation?
Yes, my lord.
Which page?
Yes, my lord. Previous litigation. Yes. My lord, page 48. In the year of 2012, the principal secretary.
পড়াই যায় না।
পড়ে দাও। This is to state that the petitioner's
illegible.
father died in harness when the petitioner was the যাচ্ছে টাইপও বলবে না, কত বলছে? Years of attain the minimum age of 18 years, though he had the requisite qualification, that is Madhyamik examination, passed the appointment as a primary teacher as per existing rules prevalent at the point of time. His application for appointment on compassionate ground was rejected as in Rule 1 of Rule 14 of the West Bengal Primary School Teachers Recruitment Rules 2001. The candidate seeking appointment, the compassionate ground must have requisite qualification in educational qualification and in age, must have to submit application to the competent authority within 2 years from the date of such date of the concerned teacher by an order dated 9/11/2011 in the Eastern matter, the Honorable Justice Indira Banerjee observed the rightly in rules with regard to the age of the son or daughter on the date of death of the employee would be unfair, more so since compassionate appointment is seldom given within 2 years, perhaps having regard to the fabulous object of compassionate appointment, the state might consider the amendment of the rules to provide for
relaxation.
The relaxation the deserving case when the candidate is of the time of appointment. The representation of the petitioner made to the school education department.
Where is the 2nd November 2011 order?
Yes. 2nd November 2000.
So the page 48, it was sent to the finance department.
Finance.
Then what happened? Finance department passed any order?
Finance department not passed any order. On the basis of that,
you preferred contempt?
Yes.
Eh?
Yes, my lord.
Then what happened? Contempt order is?
My lord, then I am showing. Then again, against that, my lord, I am not. In the I made an application on appraise before the Honorable Justice, my lord, 2015. Kindly see page 58. Before the Honorable Justice Devanshu Basa. Page 58 it starts from page 58, 59, 60. Contempt করা হবে।
কেন contempt হয়?
এই জেরক্স গুলো কোথায় করা হবো? এত ছোট ছোট জেরক্স, স্পেশাল জেরক্স করা হয় নাকি? পয়সা কম।
তো একটা করা যাচ্ছে।
করা যাচ্ছে না। কি যে করো না তোমরা কে জানো। সব থেকে কি করো?
এই তো ফাইল হলো কি করে? কিছুই তো করা যাচ্ছে না।
এত ছোট জেরক্স তো পড়তে পারে, আমি তো পড়তে পারছি।
ঠিক সেটাও তো ভুলভাল সেলাই করে দিয়েছে।
ইমপ্রেশন খারাপ হয়ে পরিষ্কার পরিচ্ছন্ন
অ্যালাউ করলো কি করে? ফাইলে কি তো আটকে দেবে? তুমি 61টা পেজটা ইয়ে করো। এইটা প্রিন্সিপাল সেক্রেটারি অর্ডার, সেকেন্ড অর্ডার। 61 সেকেন্ড অর্ডার।
হ্যাঁ,
সেকেন্ড অর্ডার পাস বাই দি প্রিন্সিপাল সেক্রেটারি 61।
সেটা তো তার এগেইনস্ট আওয়ার ফেস। ফিনান্স ডিপার্টমেন্ট
করেনি তো।
এটাই তো এটা করেনি, সে তো আছে।
So after this order, which order was passed? After 20th August
61, the principal secretary again, my lord, took up the matter and passed order on, my lord, 17/11/2015.
Page 61 or to 65. Finance department has not passed any. Principal Secretary pass this order. কোন না বছর তো দেখেছেন একই কথা বারবার বলিস
Now, in the earlier order, who was directed to consider? Secretary School Education Department was directed to consider.
Yes, that's why my Principal Secretary. That is the page 61.
No, the representation, page 60,
Yes.
read at the top, in Piyali Saha larger bench held, the embargo is on the not on the executive. The representative writ petition remains undisposed of. In such a Secretary School Education Department was.
Yes, that is the, it starts from page 61. On the basis of the order passed by the Honorable Court, Principal Secretary was pleased to pass this order.
উল্টো করে সেলাই করে দিয়েছে
Thank you for 57 days cover up করে দিয়ে অনেকটা দেরি বছরের মধ্যে চেক করে দিই
Your father died.
Father died.
Your mother is there.
Mother and son.
So mother is getting family pension.
Seeking family pension.
Mother is getting family pension. No, Piyali Saha cannot be.
Rightly said. I am not opposing. Rightly said statute itself. Rightly said, my lord.
The present appeal has been.
My submission of 47 days, it can be rounded as 18 years. That is my humble submission. It is not the case that is the 6 months key or 1 year, whatever it may be, but 47 days. Only shortfall. That shall be considered, my lord, on the aspect, my lord, on humanitarian law.
may I hand it over a copy of Piyali Saha?
The present appeal has been preferred challenging an order dated we couldn't consider. Unfortunate, but what?
Rightly.
Dismissed. Yes.
We shall try as my best level. 47 days only, that is the only point discussed. Others point had not discussed. Distress, family background, or earning, pension, not even discussed. Mr. Secretary. Develop.
আর কি আছে পয়েন্ট দেখেছো কোনটা দেখো? হুম
চোদ্দটা হলো
এটা কোনটা 14 14 15 কি আছে 15 রাখো 15 কার
Metrization. Now for the applicant.
15
Yes.
এটা কি
But this is that matter, madam.
my court officer similar matter is pending before Justice Mantha.
Justice Mantha.
Similar to this.
No, that was yes, my lord.
One matter was released by us.
Yes, that was assigned, my lord. It is not. I did not check, my lord, whether it is assigned to my lord Justice Mantha yet.
Oh, আচ্ছা তাহলে tomorrow we take it.
Well, on previous day, I shot for a 5 minutes time just to canvass the case of PH candidates.
Let them continue, we shall ask.
I am just handing over the notes, my lord, on the basis of which I will develop my argument.
Now, Mr. Tiwari, Mr. For whom are you appearing?
My lord, I am appearing for, my lord, some of the writ petitioners as well as, my lord,
Then another person will come and say some of the petitioners I am appearing.
look, there are 3 sets of lawyers who are as writ petitioners.
Can we continue? We have given him the entire evening that day. Now, if you say that I will make further,
My lord, I will not, your lordship will not kindly.
do not torture us. You can, unless you finish it.
I'll finish. Today I'll finish.
How will we record your submission?
I am saying, my lord.
No. How will we record that both of you are appearing for the?
No. He is appearing, my lord, some set of writ petitioners. I am also appearing, my lord, some set of writ petitioners.
Are we under any obligation to hear as many petitioners as
Your lordship will not kindly, my lord, your lordship will not would be delivering a historical judgment. My lord, kindly allow us to assist. Kindly assist. Can you allow us to assist, your lordship?
How much can we assist, sir? Today, if there are 140 persons and everybody says I am represented.
So far as writ petitioners are concerned, my lord, only 3 council will be making their submissions, my lord.
This way, Mr. It becomes.
Kindly, my lord, kindly, your lordship allows us, my lord, to assist your lordship.
We have never prevented any.
Yes, I know that. I know that.
If you also do not assist, when we will finish the matter?
Today I will finish, my lord, your lordship kindly allow.
Mr. Tiwari, you make it clear to your friends.
Yes.
We will not, the subsequent councils, we will not allow by-part arguments this manner. Kamlan? Next date.
But kindly takes, my lord, the recruitment rules. But on the last occasion, my lord, I handed over to your lordship, my lord.
Yes.
A document. Recruitment rules.
You are placing from what the recruitment?
I'm just placing, my lord, recruitment rules. 8.
Yes. Yes, tell us.
Wait. Now, my lord, your lordship, my lord, can you take some recruitment rules? My lord, first I will be referring, my lord, section 2B.
Yes.
Lord, section 2B says, my lord, appointment means appointment of teachers of primary school in accordance with the provisions of the Act and the rules.
Yes.
Now, my lord, section 2I.
Yes.
Section 2I, my lord, says, my lord, government, what does government means? It says, my lord, government means the government of West Bengal in education development. Now, my lord, section 2L. It is saying, my lord, panel means a list of names of the eligible and selected candidates for appointment as teacher in primary school, published by the board board of according to rules. So, my lord, the panel has to be published by the board. Now, my lord, your lordship kindly takes, my lord, next, my lord, S, 2S. It says about the vacancy. What is the definition of vacancy? Vacancy means vacant post of primary teachers, primary school teacher arising by way of creation of a new post by the council with prior sanction from the state government, retirement of a teacher, death of a teacher or declaration by the competent medical board for incapacitations of a teacher, resignation tendered by the teacher, acceptance by the council, and removal and dismissal of teacher. So, my lord, the vacancy has been defined, panel has been defined, appointment has been defined, government has also been defined. Now, my lord, kindly take, my lord, rule 4.
Yes.
Well, rule 4 says, my lord, the information regarding vacancies. The head note is, my lord, information regarding vacancies. It says, my lord, the primary school council shall prepare a report regarding the number of vacancies mentioned separately, with the number of vacancies proposed to be earmarked for that council as per note 7 of rule 6, minimum wise, category wise, for the post of assistant teachers of primary school under its jurisdiction. Provided the report shall provided that the report shall include the anticipated 10% of total vacancy for the next 1 year. Next, my lord, 2, sub-rule 2. On receipt of the report under sub-rule 1, the Director of School Education, after due verifications of the sanctioning order of the post submitted by the council and with due approval of the government, shall send the vacancy report to the West Bengal Board of Primary Education. Next, my lord, kindly skip, my lord, rule 3. Next, my lord, rule 4, sub-rule 4, 4. The advertisement for filling of the vacancies shall inter alia contain the date, place, and time for collection of the application form, the manner of submission of the application form, date and time of the vivacity interview and aptitude test. Now, my lord, kindly take one note. So far as vivacity and interview, nowhere it has been defined. Rule is silent, my lord. What does it mean by vivacity and what does it mean by interview? But so far as aptitude test is concerned, it has been defined. Right, your lordship would get the definition of aptitude test in rule 2C. Rule 2C says, my lord, aptitude test means a test to assess natural teaching ability of a candidate.
Yes.
Now, my lord, rule 4.5, sub-rule 5. Rule 4, sub-rule 5 says, with the prior approval of the state government, the board shall have the following power to lay down the modalities, procedures, and guidelines, as the case may be. Lord, my submission is, means, Lord, board has the power to lay down the modalities, procedure, and guidelines. The modalities, procedures, and guidelines in respect of, my lord, information regarding vacancies. Lord, rule 4 starts with the heading, my lord, information regarding vacancies. So this power was given, my lord, for the purpose of laying down the procedure for modalities, procedures, and guidelines, as the case may be. Now, A, the selection of candidates for preparation of panel for appointment, coordinate the entire procedural formalities relating to recruitment, and engage any specialized agency for the purpose. Now, my lord, my submission would be, before your lordship, the engage any specialized agency for the purpose means it is for the purpose of, my lord, information regarding vacancies.
How do you come to that analogy?
Now, my lord, your lordship, my lord, kindly come to rule 4 once again. Rule 4, my lord, heading is information regarding vacancies.
So information
regarding vacancies.
that will be given in terms of the rules
Rule
by the
4.
specialized agency.
And information, yes, my lord, my submission is, my lord, the specialized agency, if any entrusted, that entrustment will be on the purpose of, only for the purpose of, my lord, regarding information regarding vacancies. Information regarding vacancies, not for any other purpose. Now, my lord, kindly see, my lord, next chapter starts Chapter 3, the selection and appointment. Next chapter, that is chapter 3, heading is, my lord, selection and appointment. Now, my lord, in chapter 3, your lordship, my lord, if your lordship kindly turns, my lord, rule 7. Rule 4.5c. I will be coming to the evidence, my lord, again, my lord. Prior to that, my lord, if your lordship, my lord, kindly turns, my lord, rule 7.
Yes.
Rule 7, my lord, its heading is, my lord, selection committee. It says, my lord, the board shall constitute the selection committee for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers in primary school within the jurisdiction of the board. That means, my lord, the board shall constitute the selection committee for the purpose of selection of eligible candidates and preparation of the panel. That means selection committee will prepare the panel. Preparation of panel of such candidate for appointment of teachers in primary school within the jurisdiction of the board. Next, rule 2, sub-rule 2. The selection committee shall normally function for a period of 2 years from the date of first meeting. Now, we'll kindly skip proviso clause. Kindly come, Lord, rule 7.4. Rule 7.4 says, may I just place it? The board may, if necessary, constitute one or more other subcommittee for scrutiny of testimonials, for conducting interview aptitude test, and other purposes as may be required. The decision of the subcommittee or subcommittees shall be bound by the decision of the board. So, my lord, the selection committee is the main thing. The selection committee as well as subcommittee, my lord, board may from time to time, my lord, form. Rules 4 says the board may, if necessary, constitute one or more other subcommittees for scrutiny of testimonials, for conducting interview, aptitude test, and other purposes as may be required. The decision of the subcommittee or subcommittees shall be bound by the decision of the board.
Yes.
Now, my lord, there are 3 rules, my lord, I have referred to your lordship. One is, my lord, rule 2L, that defines the term, my lord, panel. One is, my lord, rule 2C, that defines the term, my lord, aptitude test. Now, my lord, other is, my lord, rule 4.5C, rule 7.1 and rule 7.4. Now, if my lord, if the combined reading of these rules or sub rules is made, then, my lord, it can be safely said only, my lord, subcommittee or selection committee is the appropriate authority to prepare the panel or to conduct the recruitment process or selection process.
Yes.
Now, my lord, rule 7, my lord, speaks about, my lord, selection committee. Now, my lord, if your lordship, my lord, kindly takes, my lord, rule 8, sub rule 5.
Yes.
Rule 8, sub rule 5, my lord, at page 108.
Yes.
It says, my lord, the selection committee shall prepare separate council-wise panels as per procedure below. Firstly, the selection committee shall segregate all eligible candidates applying for earmarked vacancies as mentioned in note 7 to rule 6 from other successful candidates.
Yes.
Now, my lord, B, Rule 8(5)(b). Secondly, the selection committee shall prepare the following panels for the successful candidates who have applied for non-earmarked vacancies. Now, my lord, kindly consider, my lord, it speaks about the selection committee, not from any other third-party agency. It says, my lord, the selection committee shall prepare the following panels for the successful candidates who have applied for non-earmarked vacancies. Number 1, 5B, number 1. It says, a panel of all selected candidates in the district, namely unreserved category comprising the name of the candidates belonging to general category and reserved category of scheduled caste category, scheduled tribe category, OBC category A, OBC category B, PH category serially according to descending order of merit as per existing vacancies medium wise. So, my lord, a panel should be prepared, my lord, containing the names of, my lord, the reserved candidates as well as, my lord, unreserved candidates. It is not a panel for, my lord, for reserved candidates or unreserved candidates. It is a panel, my lord, in short, my lord, from reserved to unreserved. It will go down. Well, I'll show to your lordship, my lord, in 2009 as well as 2022 also, the board has prepared the panel in the same manner. But here in this case, I will also show to your lordships, the board has prepared the panel in separate segment wise. Well, it cannot be. So, my lord, everything has to be done by the selection committee. Now, my lord, kindly takes, my lord, the rule 5. Then your lordship, my lord, kindly come to, my lord, note 1. That is, my lord, rule 8(5), clause 4, note 1. Page 109, top. Note 1 says, such an alternative set of panel of selected candidates for each category in a council shall be prepared for the purpose of providing a option of reserved category candidate during the counseling to opt for posting as per position in the unreserved category or as per position in the reserved category. So, my lord, what does it mean? It says, my lord, suppose, my lord, I am a meritorious candidate. My lord, I am a meritorious candidate, but I belong to the SC category. But my name should be, my lord, included in the general list. My lord, if I cross the, my lord, minimum cut-off marks, my lord, I am a meritorious candidate, my name should be included in the, my lord, general list. Consisting of, my lord, reserve, unreserved, and all these things. So, my lord, I have the option. I can take my.
Sorry, my lord,
Lord, I have not interpreted. I have not interpreted, sir.
These are the no.
You will get your chance in the reply. You will get your. No. I have not. Yes, I can shout better than. A reserve candidate. Suppose I belong to the SC community.
You get an option to choose your vacancy.
Yes.
Very
But
good.
no option was provided. No option was provided. Now, my lord, this is my case that had the option been provided, then, my lord, general cut-off mark would not have been 10
and SC cutoff mark would not have been, my lord, 20.
For that, you have to come within the zone of selection. No?
I'll be demonstrating.
Rider will come there.
I'll be demonstrating that.
Acha, very good.
Now, my lord, kindly turn, my lord. Next, my lord, if your lordship, my lord, kindly turn, my lord, rule 8, sub rule 9. That is, you will get, your lordship would get, my lord, page 110.
Yes.
Now, my lord, rule 8, sub rule 9 says, if in the process of recruitment or even after the recruitment at any stage, it is detected or proved that a candidate has achieved the success by way of unfair means or by suppression of some material facts, his or her appointment shall be summarily be cancelled. Now, my lord, kindly turn, my lord. Next, I will be referring, my lord, rule 9.
What is your argument?
I'm just placing these rules. I'll make
It
my
has been placed before
No,
us.
rule.
You can come to your argument referring to
Yes, my lord, my submission is this, my lord, that committee or selection committee is not powerless. If there is some detection that somebody has actually got the service, my lord, by way of illegal means, it can be strike down. It can be strike down, my lord, at any moment by the court also. So, my lord, it is not that, my lord, that if something has already somebody has achieved something by an illegal means, he cannot be touched. He is always touchable.
All right.
Now, my lord, rule 9 says the approval of panel. The panels, after being prepared, shall be accorded approval by the board and thereafter shall be sent to the respective district primary school councils with all necessary papers for appointment.
Yes.
So, my lord, again, board, panel and board.
Yes.
Now, my lord, appointment letter. Rule 10. The district primary school council on receipt of approved panels shall call the impaneled trained candidate. What is the panel? I am asking the question to myself. The appointment shall be given to the impaneled trained candidates first for counseling for the post in accordance with the vacancies, medium wise, in terms of the option exercised by the impaneled trained candidates, and thereafter the impaneled untrained candidates in the following manner. So, my lord, there must be a panel. Otherwise, somebody could not be in
It has
impanel.
been argued, Mr. Tiwari, that there was no
kindly-
publication of panel.
Kindly,
it was not
kindly,
in the
kindly,
public.
bear me, my lord, 15 minutes. Within 15 minutes, I will conclude this. Within 15 minutes. Then I will be going to the later part. Now, my lord, kindly turn, my lord, next. Rule 11.
Yes, this has also been placed.
Yes. Now, well, I am not placing it. Now, my lord, rule 12 says the validity of the panel, it is for 1 year, it can be extended.
Yes.
Now, my lord, last rule I will be referring to your lordship, that is rule 22.
Yes.
Now, rule 22 says, my lord, a reference to the state government. If any difficulty arises in implementing any provisions of these rules, the matter shall be referred to the state government and decision of the state government thereon shall be final. Now, my lord, I will be, my lord, concise my argument, my lord, on 2 parts. Only on the issue of corruption, my lord, I will say. Now, my lord, corruption, my lord, consists of, my lord, 2 parts. One is, my lord, interview, and other is, my lord, aptitude test. Well, let us proceed, my lord, first with the aptitude test. If your lordship, my lord, kindly turns, my lord, text, my lord, volume 2, page 421. Page 421. I'm sorry, my lord, I'm just refer one page of volume 1. That is page, yes, page 120. I'm sorry, my lord.
Yes, that is the advertisement.
Yes, kindly take some. These are most legible copy.
Yes.
Very good. Now, if you see, my lord, takes the advertisement that is dated 26th of September 2016. Kindly see, my lord, clause 5. That is, my lord, procedure of selection. But taking into the recruitment rules, my lord, in background, my lord, kindly may I just place it. It says, my lord, the selection committee, after prima facie scrutiny of the duly filled applications form submitted by the candidate having requisite qualifications, shall notify the date, time, and place of scrutiny and verification of testimonials of the applicant, those who have duly filled in online application form for appointment. Thereafter, the selection committee shall notify the date, time, place for the vivacy interview and aptitude test of all qualified candidates. The performance of the candidates who will be called for vivacy and aptitude test shall be assessed by the interview board formed for the specific purpose. Thereafter, the academic qualifications, training, performance in teachers eligibility test, extracurricular activities, vivacy interview, aptitude test of or teaching experience in case of para teacher shall be computed in the following manner as mentioned in the table. So, my lord, it also says about the selection committee. It also speaks about
what you are hinting at.
hinting, my lord, I will be coming. Hinting is, my lord, the board, president of the board has said that third party was engaged in terms of Rule 54C.
Yes.
I am saying, my lord, in terms of Rule 54C, it cannot be done. Third party.
That is restricted to information.
Yes.
Very good.
Now, my lord, that is, my lord, my main submission is this, my lord, the entire procedure followed by the board vitiates the rule itself. It is not in accordance with the rules. They have given, my lord, the total go by of the recruitment rules.
Yes.
Now, my lord, if your lordship, my lord, kindly text, my lord, page 421, my lord, volume 2.
This is not your, it is not your case that aptitude test, none of the persons were called or not notified. Your case, the learned single judge observed, at one place his lordship said that there was aptitude test in view of the deposition of the candidates, and another phrase they say there was no aptitude test.
30 interviewers are called, 30.
Very good.
Most of them say there is no.
No, this is the facts.
Yes,
Facts.
this is the fact.
So, as per 5, it is not a case that you did not have any knowledge about the date fixed for interview or viva voce. Maybe some of you said, sir, we were not notified. We didn't know. So you are trying to bring it down to the contents of corruption.
Yes.
So please answer us one thing, that there are, say, suppose I was a participant. You say that there is a fraud in the recruitment process. Then how do you link me?
No, my lord, if your lordship,
I maybe have been a victim of the fraud which has been committed.
no, my lord,
Can it not happen, Mr. Tiwari?
100%, my lord.
Suppose you and myself and your brother appeared in a selection test.
Yes.
Now, myself, in that selection press, there is a fraud. We are trying to seek your response to this, that how do you link me with the fraud? I am a participant.
As because, my lord, that particular gentleman is a beneficiary of the fraud.
No. The court said that as if jobs have been sold.
Yes.
So what do we understand by sold? That I have given money, so you have given me appointment.
Yes.
So you linking the entire fraud, I don't know, that submission has not come to us, that there was good, bad, indifferent, there was a fraud, suppose, admitted. Now, if that is a fraud, I was a participant in a fraudulent process which was conducted. But What is my fault, sir, when the fraud has been perpetrated by the persons who conducted the proceeding? How do you link me with that fraud? We were wanting an answer.
As because most of them are the beneficiaries of the fraud.
How do you?
I'll be coming. I'll be coming.
No, Mr. Tiwari, we are asking, suppose in respect of the entire education system, the CBI, ED, everything, investigation is continuing. You also don't know when it will end. I also don't know when it will end.
Yes.
So only upon conclusion and pinpointing of the actual perpetrators of fraud, we can come to the conclusion that these persons who have been appointed were also included in that.
Milord, kindly, if you Lordship, Milord, kindly consider two things. The two dates are very important. One is Milord 28/11/2022.
That is the date of publication of the marks.
Another is
and the
Milord
breakup.
23/5/2023.
But the judge before Justice Orijit Banerjee, when was the writ petition filed?
September.
In that writ petition, this is the identical argument which was advanced.
Milord, these documents were not available before any of the learned judges.
All right, we have
no documents were available.
When he argued,
Yes.
he also told us that how I will know that what is inside that bag unless you
Milord,
disclose.
kindly consider one thing. Today, Milord, kindly see, Milord, the concept of justice.
Very
Milord,
good. Now
yes.
you proceed.
Yes.
You come down to the issue of corruption.
I will be coming down to that issue.
Yes, sir. Yes, sir.
Yes. Now, Milord, kindly text Milord page 421.
Yes. 421 is the
Order.
advertisement. Huh?
Now, 421 is the order passed by the
No.
second paper.
Anything more in the
No.
advertisement? Yes.
Now, Lord, this is the order dated, Lord, 17th of January 2023.
Yes.
May I just place it, Lord? In the course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, when the stage of interview and aptitude test came, the only interview was taken and there was no aptitude test, though in the aptitude test, there are 5 marks and 5 marks are also for the interview. A large number of petitioners were present in courtroom. I decided to exercise my power. Under section 165 of the Indian Evidence Act, I asked some questions after administering oath to 7 of such candidates, being the petitioner number such and such and such and such. Next. Page 422.
To this, the argument was that why 7 persons?
Why? No, actually, we
We are
yes.
just telling you what were
Yes.
the.
So why?
Correct us if we are wrong.
As because these 7 persons belong to 7 different districts. That's why, my lord, after identifying that petition number 1 is from that district, petition number 3 is from that
There are
district.
20 districts.
Yes. Plus,
20.
Not
21.
21. These petitioners were present in court, and out of these petitioners, only persons who are belonging to the 7 districts, they had been taken into consideration. Now, my lord, next page 422 says, from their evidence, I am satisfied. There is no aptitude test for the said petitioners. Now, learned advocate for the board has submitted that he does not have any idea whether such aptitude test was taken or not. Next, in such circumstances, I direct the President of the West Bengal Board of Primary Education to file one affidavit by 7 days from the date disclosing whether there was any aptitude test in 2016 selection process and what is the method of the board in following this year to be taken to take aptitude test of the candidates. Now, we'll kindly see the affidavit of the board.
359.
359.
Starts from 363.
Now, we'll kindly text 362 paragraphs I will be referring.
3
It starts at, my lord, page 359. Kindly turn, my lord, page 360. Paragraph 3.
It's 360.
360. Lord, 359 is a affidavit in terms of the law order dated 17th of January 2023.
So you are showing us 360 paragraph
Paragraph 3, 4.
3 and 4. Yes.
Paragraph 3 says,
I assume
I assume the office as president of the West Bengal Board of Sergeants on 24/8/2022. I was not the president of the board when 2016 recruitment process was instituted and subsequently completed. Next, from the records available in my office, it is evident that in the 2016 recruitment process, marks were given by the selectors both in interview as also in aptitude test to the candidates. The my lord, president is said records are available. But I will be showing to your lordship, my lord, the affidavit affirmed by the president saying the records are not available.
Yes.
Now, my lord, the president, my lord, has affirmed, kindly takes, my lord, another order, page 423.
Page
423.
Next order.
Next order.
Yes.
Now, it is order dated 24th of January 2023.
Yes. Yes.
423.
Yes.
It says, my lord, I directed the petitioners that at least 2 candidates from each district are to be present before this court. And this court wants to know from them about the interview and aptitude test taken by the West Bengal Board of Primary Education in 2016 selection process. I am told by the learned advocates for the petitioners the candidates are present. Say, my lord, kindly skip it over, my lord. Kindly turn, my lord, page 425.
President directed to file.
Yes. I direct the president of the board to file one further affidavit explaining what is the aptitude test, and this explanation is to be given after consulting the expert and all these things. Now, my lord, in terms of this direction.
This is page 365. Right?
Yes. This is, my lord, page affidavit starts at page, my lord, 363.
No, that is, I think that is not. You have anything to show from that evidence?
Yes,
that is an explanation.
Explanation regarding aptitude test. My lord, only one thing, my lord, I will show to your lordship.
This is page
375.
Yes.
Now, my lord, paragraph 11 and paragraph 12.
Paragraph 12 is important.
Paragraph 12. Paragraph 12.
My lord has read now all pages.
Paragraph 12.
Paragraph 12, my lord, last 4 lines. The interview vivacy aptitude test was conducted at the centers under the respective district primary school council and primary school council, and there is as such no distinctive records which was kept and maintained in the recruitment process, wherefrom it can be ascertained as to which the interviewers took the interview vivacy and aptitude test given to the candidate at a given center in the particular room in 2016 recruitment process. No methodology is suggested that the details are required to be maintained by examining body, however such and such. So, my lord, he is saying, my lord, records are not available.
Records pertaining to what questions will be put in
pertaining to, my lord, 2016 recruitment process, my lord, regarding aptitude test and all these things.
Subject to correction. You cannot link this statement with what you have said in page 359.
Yes, page.
From records available in my office.
Page 360, paragraph 4. Kindly read, my lord, page.
So your argument is in one paragraph it is said records available. Next paragraph he says records.
Now, my lord, kindly turn, my lord, page 376 once. Next page. In the jural portion, my lord, you will also find how he is affirming the statements made in paragraph 1 to 3 of the foregoing affidavit are true to my knowledge, and those made in paragraph 12 thereof are based on information derived from records. In one page, page 360, you are saying no records are available, and in the next affidavit, you are saying the records are available, and I am affirming this affidavit on the basis of the information derived from records. So which one is correct?
Yes. Anything else?
Now, my lord,
Mr.
kindly turn, my lord, page, my lord, 427. Page 427.
For 27, yes.
My lord, it is order dated, my lord,
6th February.
6th February.
Yes, Mr.
My lord, I am not troubling your lordship, my lord. If your lordship, my lord, kindly text, my lord, first paragraph. Today, the affidavit of the West Bengal Board of Primary Education explaining what is aptitude test has been filed, and same is kept to the records. Copy of the same has been served upon the petitioner. Kindly turn, my lord, page, paragraph 4. Let me also place paragraph 2. The letters issued by the board to different experts as to the aptitude test were in a sealed cover which has been opened in court, and those letters are kept inside again after perusal of the same by this court, and that envelope should be sealed again. So, my lord, the names of the interviewers were supplied by the board. It is not me, my lord, I have supplied the names of the interviewer. Board was asked to provide the names of the interviewer, and they provided it in a sealed cover, and after perusing those names, the court again sealed it.
Yes.
Now, my lord, kindly run, my lord, page next paragraph 4, page 428. Out of the interviewers of the following districts, namely Hooghly, Howrah, Uttar Dinajpur, Coachbihar, Murshidabad, I need to know some facts from the interview, about the interview and the aptitude, and whom I call from appearing before this court on 21st of February 2023 at 2 p.m. And the expenses of their journey would be paid by the board. I do not want to settle such and such. Next page, my lord. The matter was adjourned till, my lord, 21st of February 2023 for, my lord, examination of interviewers. Now, my lord, next. It says, my lord, for the district of Hooghly, I call the persons named in serial number 1357 and 20. For the district of Uttar Dinajpur, I call the person serial number 3243 of the list.
These are the interviewers.
So, my lord, these are the lists provided by the board. I have nothing to do. List provided by the board, and court called out of these lists, these persons. So, my lord, it is not the case, my lord. I have provided the list. I have provided the name, and on the basis of
nobody has alleged that against you.
the arguments were made to that effect also.
No. That allegation was not that you have given the names of the interviewers.
Next, my lord, page 431.
Yes, 430.
431 is a, my lord, date, my lord, which was fixed on 21st of February 2023 at 2 p.m. It was fixed, my lord, on 10:30. But it is not so relevant, my lord. Relevant is, my lord, page 432. Order dated, my lord. It is, my lord, wrongly typed, my lord. It should be 21st of
February 20.
Now, my lord, in this order, your lordship would find, my lord, the as many as 30 interviewers were the evidence was taken, my lord, from the 30 interviewers, and not only that, my lord, page 434 is also, my lord, significant. First paragraph, where the chart closes, my lord, that no question was asked by the appearing parties to the above interviewers. The evidence recorded are kept on record. But nobody can say that I was not given an opportunity to cross-examine the interviewers. The board was there. Board is the main contesting party in this proceeding. The board lawyers will not could have will not examine or re-examine or cross-examine will not these interviewers.
Even if it is not done, what will be the what is your answer on totality?
Well, my answer is totality, my lord. In most of the cases, my lord, most of the interviewers have said
that
no aptitude test.
Yes.
The person who said aptitude test was there was no violation.
And two things are there, my lord. There is no aptitude test, and some persons have said that aptitude test was conducted, but there is no guideline. No guideline at all. Which, my lord, subsequently, president of the board has said, and these are the guidelines. But these guidelines were not at all followed by these interviewers.
Which guidelines are there?
President of the board, my lord, has said, my lord, explained the aptitude test in terms of the order passed by a single judge.
No, you are saying guidelines. Guidelines were there.
Guidelines were there for the purpose of conducting aptitude test, but interviewers have said, there was no guidelines provided to us. So, my lord, it can be logically concluded there was no aptitude test at all.
Where is that guideline page?
No, guideline is not annexed here.
That is with you.
That is with me.
You place it when we hear the when at the time of reply. You please give us a call. Yes. Yes.
Now, my lord, if your lordship, my lord, can you transfer page 437?
Please write it down, Mr. Biswas. Otherwise, 437. Now, this brother talks we will not allow. This kind of, I have missed that you put it.
Now, my lord, page 437 is the, my lord, order dated, my lord, 5th of April 2023.
Yes. What do you want to show?
Now, my lord, I want to show, my lord,
President question.
yes.
Yes.
Now, kindly turn, my lord, page 438.
Yes.
Now, my lord, page 438.
Question, come to question 2.
4. Question number 2.
Yes.
Who published the result and who prepared the result of 2016 selection recruitment process? Does not understand the question. Then he said that it is compartmentalized and made some statement as to the compartmentalization.
Where are those statements?
Milord,
That is not
Milord, so far as Milord, this what is the exact meaning, Milord? My different so far as president is concerned, Milord, president might have wanted to say the correspondence has been done in different compartment manner.
Exactly.
Yes,
So,
Milord, it has been done in a compartment wise.
No, evidence.
Foggy wise.
The evidence has to be recorded subject to correction, as I have said.
Yes.
If I say that, if I say you will ask the steno to record that statement, this is correct us. If we
Absolutely correct, Milord. Your lordship is absolutely.
Other would be more aware.
Yes. Justice Mitra is well acquainted with this evidence. Now, Milord, so far as
So you
Milord,
answer my brother's question.
Milord, so far as Milord, this statement is concerned, he said it is corruption has been done in compartment or segment wise. Otherwise, Milord, this question is not apparent. Milord, nobody, a president of the board, Milord, cannot understand this question, Milord. It is hardly to believe. Who published the result and who prepared the result on 2016 recruitment process? But a rocket science is not required, Milord, to understand this question.
Yes.
Now, Milord, question number 3. whether any outside agency was engaged to prepare the result of 2016 recruitment process. The answer is, my lord, the board has acted in accordance with Rule 4.5 Clause C of the West Bengal Teachers Recruitment Rules. The Rule 4.5C
That
is
is
absolutely
pertaining to
different.
information of
Yes,
vacancy, not interest.
information regarding vacancies. So, my lord, Rule 4.5C, my lord, has no bearing to the, my lord, preparation of the panel. It has to be done by the, my lord, selection committee.
So your contention is this rule is not applicable in this.
If this rule is not applicable at all, and even if, my lord, third party is engaged, my lord, I am assuming for the moment, my lord, the statement given by the erstwhile president, my lord, in evidence, my lord, the Rule 4.5C was invoked. That is invoked for the purpose of, my lord, preparation of, my lord, information regarding vacancies, not for any other purpose. That is for the information regarding vacancies. The question is, was any specialized agency engaged? Answer is yes. Next, what is the name of the agency? I have to go through the records. I cannot remember. Next, have you ever heard the name of P. Vasu and Company? Maybe I am not sure. I have to go through the records. Next, did you know whether any aptitude test for the candidates was taken? Yes, of course, the aptitude test was taken. There is no report during my tenure as the president of the board that aptitude test was not taken. Next, my lord, question number 8. Are you sure that the reservation norm was followed in 2016 recruitment process? Answer. Reservation policy was, as was incorporated in the rule itself, was followed. There was no allegations or information during my tenure that the reservation policy was not followed. Now, my lord, I will be showing to you, lordship, my lord, that
you have showed reservation was not that he has elaborated on.
Kindly consider, my lord, I kindly allow me, my lord, to place these two files. Kindly,
For
just
what? For
for
what?
showing, my lord, how it has been done.
That has already been shown.
There are other points are also.
So that is addition. That is addition.
It has been circulated, my lord.
No, my lord, I am not circulated,
That
my
is
lord.
Soft copy.
No, my lord.
Mr. Tiwari, you will be arguing. He has already shown us from that blue volume
Only two
that
things.
the last panel candidate general was
I
10 marks.
will be arguing, my lord. The reservation policy which has been followed by the board, it is a communal reservation.
What?
It is a communal reservation. Yes.
So that is not in your writ petition.
Your lordship is not hearing
the
the
first time you are raising this.
No, but kindly consider, my lord,
where
today,
you raise this issue
today, my lord, your lordship is deciding. My lord, kindly consider. Today, my lord, kindly, my lord, your lordship, my lord, is deciding the issue, my lord, which has a vast impact. Vast impact, my lord, kindly consider.
Tomorrow you will come
No,
and
my
say
lord, these are all question of law, my lord. This is not nothing.
question of law has to be borne through the records. Show us one line.
Reservation, my lord,
Where it is
My-
communal
My
reservation.
junior,
not personal.
how it is communal reservation, I'm saying.
Mr. Tiwari,
I'm just saying.
Don't justify a case which is not there.
No, I'm just saying. These documents were shown to your lordship. Why I'm saying it is communal reservation?
Sorry,
Just
Mr. Tiwari, we cannot allow you to do.
kindly be explained. The documents which my junior has referred.
Noted that
Kindly, my
he
document.
has shown us Rule 12 and observations of the reservation rules. He has made extensive submissions. So now you can. Yes, any other point? please
There is a judgment, my lord, passed by learned single judge of this honorable court, saying, my lord, that no panel was prepared, and that is the stand, my lord, in the order itself. I'll be referring, my lord, few pages. I'll allow me, my lord, few pages of this book.
No, that you have argued that there was no publication of panel.
There is no publication of panel. Not only that,
And to that they have said we have pasted the panel on the office board. This is their argument. I don't know what they will say in reply. You have already said that.
so far as panel, my lord, how the panel is to be prepared, my lord, kindly takes, my lord, 2 pages. I will just show to you, lordship, how.
Showed us from the rules what.
No, my lord, in 2009 and 2022, they prepared the panel. How they have prepared? 2 pages. I will show them.
Kindly, my lord, do not allow. My lord, I request your lordship, my lord. My lord.
He wants to. What you are circulating?
There's 2 pages. 2 pages. I will show how the panel was
No,
prepared.
you tell us now what was said.
What I am saying, my lord, today, my lord, a panel has to be prepared, my lord. A general list has to be published. General list containing.
That is provided under the rule itself.
General list containing, my lord, kindly hear me, my lord. General list, my lord, containing the name of the, my lord, unreserved candidate as well as the reserved candidate. Now, unreserved means general category candidates as well as, my lord, reserved category candidates, that is SC, ST, OBC, A, OBC, B, physically handicapped and all these things.
Earmarked vacancies.
Now, my lord, total panel is to be, my lord, published. Now, my lord, suppose being an OBC candidate, my lord, my lord, secure, my lord, suppose cutoff marks is, my lord, 20. I secure, my lord, 25 marks. My name would be there in the general list. My name would be there in the general list. My name would also be there in the, my lord, category-wise list. My lord, there must be a general list. There must be a SC community list, ST community list, OBC A list, OBC B list, OBC list. What they have done? My lord, because my name is there in the, my lord, OBC A list, they have not included my name in the general list. My lord, what they should have been done, my name.
Your argument is, first of all, there should be one list,
one panel,
including names of candidates appearing under various categories and posts. One mother panel. So from the mother panel, there will be segregation of.
Your lordship, kindly takes 1 page, my lord. This 2009 selection panel. Kindly see. Kindly see, my lord, 1 page. 1 page.
This page.
Kindly takes, my lord.
Page.
Kindly takes, my lord, page 5.
Page 5.
Page 5 of this book.
This is state panel. State 2014. Page 5.
Kindly takes, my lord, to page 63.
Page
63. Page 63. A lawsuit find, my lord, in the panel, the 2009 panel. A lawsuit find, my lord, first name, that is, name is there.
No, what is this? What you are showing this? Subcategory Bengali, category unreserved.
Yes, this, my lord,
merit panel for the appointment of primary school.
Right. Total, my lord, subject.
This is in respect of Malda.
Malda district. 2009. Can you see? First one is, my lord, number, the person who top.
Is SC.
2009, my lord, the person, my lord, who topped the panel belongs to, my lord, SC community. Next, my lord, the person, my lord, second, my lord, general. Then SC, OBC, general, OBC. Then your lawsuit find, my lord, in the panel, my lord, all were included.
As per marks. This is as per marks.
This is as per mark.
Very good.
So, my lord, why I am saying, my lord, is communal reservation.
No. This is subject Bengali. You are saying there has to be a mother panel of all categories, or where is that?
Subject wise. subject-wise panel in respect of, my lord, all candidates.
Very good.
Subject-wise.
Hmm.
District-wise and subject-wise in respect of, my lord, all candidates. Now, my lord, kindly consider one thing. Today, my lord, I secured, my lord, more marks, but I have been, my lord, put in, my lord, category-wise panel. It is not permissible. This is called, my lord, common resolution. You know, I cannot, the board cannot restrict me.
He has not restricted.
He has restricted me. You know, I cannot go
So
there.
when on the basis of that list, when you are subject to what we have seen, that on the basis, you are OBC top in the panel. Now they are preparing separate panels for OBC also. So your name will also feature in OBC. Now, when you are called for counseling, you will say that my marks is this, I come within the general panel, you give me a general. That is what you have to point us to. That was the argument before Justice Banerjee.
Now, my lord,
Justice Bhattacharya.
now, my lord, even, my lord, general candidate. Suppose, my lord, I am an OBC.
I wanted to know where from this additional alternative panel came.
My lord, question is, my lord, kindly consider. Today, my lord, in the panel, my lord, a general category candidate is getting, my lord, chance by scoring, my lord, 10 point something.
Yes.
Now, my lord, a person, OBC category candidate, my lord, after scoring, my lord, 14 marks, he is not getting employment.
Why not? Why not?
Then that has been done in this case. That has been done in this case. My lord, once I, my lord, cross the, my lord, general category cutoff, I cannot be considered, my lord, an OBC candidate.
For that, you have to exercise the option. No?
Lord, had the option been given, then the question would have been there.
Your so you are agreeable on this issue that there was a provision for option.
There was a provision for option. There was a provision for
not
aptitude
allowed
test.
to exercise that.
Yes, my lord, there was a provision for option. There was a provision for aptitude test. There was a provision for interview, but nothing has been followed. This is my case.
Thank you, Mr. Mithra. Yes,
Lord,
who is next in line?
No, my lord, kindly, my lord, allow me, my lord, some place judgment, my lord, to that effect. Kindly.
You said you are taking 15 minutes, Mr. Tiwari.
Kindly, my lord, you lost me, kindly allow me, my lord, to place some judgment.
You have this. You have not given it in the note.
I am giving them a note, one volume.
Only one volume.
Two volumes. Two volumes.
But only this much judgment. You have something in
আর তো বলতে হবে না বলছি
ওর নামটা will look into.
Yes, my lord. Prior to that, my lord, only one page, my lord, in volume 2 of the paper book, my lord, where, my lord, the board has said the kindly takes, my lord, one page. I'll just show one page, then I'll not be making any argument so far as this.
Yes,
page 385.
Affidavit of the chairman.
Yes, this is the, my lord, opposition of the board.
Page 385.
385. It, my lord, starts, my lord, at page 378. My lord, Deputy Secretary, my lord, affirm this affidavit on behalf of the board. And page 385, first paragraph, last two lines. It says, my lord, the panels pertaining to 2016 recruitment process expired on different dates between 30th January 2018 to 22nd September 2020. So, my lord, this statement will show, my lord, there was no panel at all.
Why?
My lord, kindly see, my lord, the panel, my lord, its statement is the panels pertaining to 2016 recruitment process expired on different dates. 2 years, my lord, in between 2 years. The different dates. And my lord, it was also say how this panel was prepared, how this was done, nothing has been stated, and only this statement is there. The panels published in 2016 recruitment process expired on different dates.
Yes.
Now, my lord, so far as judgment is concerned, my lord, first judgment I will be showing the ratio. That is,
you tell us the proposition.
proposition, my lord. These 2000
paragraphs. What are the paragraphs you are giving?
Lord, first,
Uh,
Lord, this is, my lord, unreported judgment, my lord. WPAP 203 of 20.
paragraph.
Lord, paragraph 16.
16. Yes.
WPAP 203 of 2022.
16.
Paragraph 16, paragraph 17. Paragraph 19. 16, 19, 21, and 22. Well, this is in respect of same selection process. A public interest, what happened in this case? The background of this case.
The public interest.
What is the background? A person was working as primary school teacher in the district of Uttar Dinajpur. Now, one day, head teacher of that particular school asked for his appointment letter. The appointment letter was given to him. The head teacher did not hand over the appointment letter to him. Second day, head teacher told him that don't come to the school on and from tomorrow. Now, he moved the petition before this Honorable Court, saying, Lord, that I was given an appointment, but subsequently my appointment letter was taken by the concerned head teacher of the concerned school. Now, Lord, thereafter, a report was called for. Board has said he did not pass state who have wrongly given his appointment. Now, my lord, he has used a reply to the report filed by the state. He has stated, the look here, I was appointed. There are so many persons who are appointed in the same district. Now, my lord, learned judge took the petition and transformed into a public interest litigation. Now, my lord, matter was pending before the Honorable Division Bench. The division bench was hearing the matter. Now, in the meantime, what board has done, board has filed an appeal challenging the order passed by the learned single judge. In the appeal court, board has taken 100% U-turn, saying, no, he is having all documents. He is having all documents, he qualified test, he is a better candidate, best candidate. So, what Honorable Division Bench has done, set aside the order of the Honorable Single Bench. Not only that, Honorable Division Bench treated the public interest litigation as on days list, and it was disposed of. Now, my lord, subsequently, I filed
that paragraph.
Now, if you allows me, my lord, then my lord, I can place
Not
it.
allowing you. You have given the paragraphs. We
Yes.
will look into it.
My lord, kindly turn, my lord. My lord, kindly page 6, paragraph 10.
You have not cited paragraph 10, 16, 17, 19, 21, 22.
Sorry, my lord, kindly turn to page 10. Facts is there, page 10.
We shall look into
Yes.
it. You're the proposition, what you are submitting, that there was illegality and
Division bench came to a conclusion there is an illegality in the entire selection process. And this order was challenged before the Honorable Supreme Court. Supreme Court did not touch this order. This is in respect of 2016 selection process. My lord, kindly consider one thing. In the single bench, board is taking some stand. In the division bench, board is taking contrary stand. And on the consent of the parties, my lord, the appeal was allowed. Order of the single judge was set aside. Not only that, the public interest litigation, which was hearing by the division bench, bench number 1, division bench number 1, that was taken into consideration and treated on days list, and it was also disposed of. Kindly see, my lord, paragraph 10. Kindly see. Page 6, or running page 6, paragraph 10. May I just place it, my lord? Record reflects that WPA 265 of 2019 in the matter of Swadesh Das versus State of West Bengal and others, who was filed earlier, wherein an issue was raised that 12 candidates were given appointment who were not having requisite documents relating to TET 2014 qualifications and participation in the recruitment process of TET. Learned judge, taking note of the fact, by order dated 27th August 2021, had converted the petition number 265 or 2019 into appeal and directed for placing the matter before the Honorable Chief
This is pertaining to TET 2000.
No, TET is the mother.
Maybe.
TET, it is not from TET 2016 recruitment person comes. Without TET, there cannot be any 2016 recruitment person.
Next judgment, Mr. Diwali.
Well, in this judgment, my lord, if you lordship, my lord, kindly see, my lord, paragraph 12 once. What 12 says, my lord? It says, my lord, meanwhile, the order of the Honorable Single Judge dated 27th August 2021, passed in WPA number 265 of 2019, was challenged in appeal in matter number such and such. Division bench number 4, by order number such and such, only dispose of the appeal, setting aside not only dispose of the appeal, setting aside the order dated August 27, 2021, but also dismiss WPA 265 of 2019, which was being regularly taken up by the division bench number 1, that is the Honorable Chief Justice. The DV number 4, while disposing WPA 265 2019, held as follows. Now, we will kindly see last, since we don't find any element of public interest, the order impugned dated August 27, 2021 cannot be withstand, and the same is set aside. The instant appeal is such and such. In view of the finding recorded above, the writ petition being numbered is also disposed of. But there must be a limit of fraud. These are the instances of fraud.
Next with judgment, Mr. National Fertilizers.
Now, my lord, in National Fertilizer,
Paragraphs.
Paragraph 2006, volume 5, SEC 493.
Yes.
2006, volume 5, SEC 493. My lord, paragraph 23, 24, and 26.
On the point?
On the point, my lord, that recruitment rule was not followed. But running page 27 of this spiral binding.
Yes, next, Pramod Kumar. Paragraphs.
Now, my lord, the next judgment is, my lord,
Pramod Kumar.
Yes, 2008 7 SSC 153.
Status.
Blood paragraph 2930.
30.
Paragraph 29, 30, and 31.
Identical issue.
Identical issues.
Next, Krishna.
Now, my lord, next, my lord.
Krishna Jawada.
Now, my lord, 1994 4 SCC 165.
Yes.
Now, my lord, kindly, my lord, allow me, my lord, to place these paragraphs. Yes.
Paragraphs.
Paragraph, my lord, I'm just placing to your lordship, my lord, paragraph 16 to 21 and 23. Page 40.
Yes.
My lord, kindly allow.
On what proposition?
This is the, my lord, identical case with this case.
So very good. We shall look into it.
Kindly, my lord, one paragraph. My lord, kindly, may I just place it.
Which paragraph?
Paragraph 16, my lord, kindly see. Paragraph 16, 17, and 18.
Page, running page?
Running page 49, 49.
Yes.
It says, my lord, having regard to all above, the irresistible conclusion is fraud has reached its crescendo. Deeds as sole of these as inconceivable, much less could be perpetrated. We are.
Achha, don't remind us Shakespeare. Let us go to the next.
Now, my lord, next paragraph 17, my lord, can you have a look? Paragraph 17 and 19. If you lord, I am not present. Now, my lord, next, my lord.
Yes. Vishwaranjan Sahu.
Vishwaranjan Sahu and, my lord.
Paragraphs.
That's page 53. Agree, sir. Agree. This is 1996 5 SSC 365.
Yes, paragraphs.
Paragraph 3. This is not in respect of principle of natural justice. But it is not an unruly horse. There is. Now, my lord, next, my lord, page 56.
Gunwant Kaur.
Yes.
Paragraphs.
1969 3 SCC 769.
You said 96 3 SCC. Gunwant Kaur.
Gunman Kaur, my lord, 1969 3 SCC 769, page 56. Page 56. Next judgment.
You have given it 1996.
In the index.
In the index?
Sorry.
হবে না, yes, what is the year?
My lord, can you turn page 56?
1967.
1969 3 SCC
Hmm.
769.
You have referred 96 3.
Lord, paragraph 14, 15, and 16.
On the proposal.
On the point, my lord, the power of the court, my lord, under Article 226 of the Constitution of India. Lord, 2007, volume 4 SSC. Volume 4 SSC, page 54. Paragraph 26, 27, 28, 31, and 32.
Yes, next. 1815 SCC 463. Paras.
Lord, 2018-15 SCC 463.
Paragraphs.
Paragraph 24 and 25.
Yes.
2018-15 SCC, page 463.
Then 2010 volume 13 SCC 255. Paras.
97. Joseph Purnam.
Paras.
Lord, 2010-13 SCC 255. Paragraph 25 and 27.
আরেকটা কি হলো 10 একটা 3 13 কি সব বলছিল
Now, my lord, kindly text, my lord, next one, my lord.
13 দুটো বলেছে
2010-13 SCC, my lord, 255.
Got it.
Yes. Next, my lord, 2014 SCC online Tripura 291.
Paras.
My lord, kindly read, my lord, kindly allow me, my lord, to place few paragraphs of the similar facts. My lord, where to 10,000 and more, my lord.
Paragraph.
Paragraph, my lord. 2014 SCC online Tripura 291. My lord, paragraph, my lord, 102, 103, 116, 117, 118, 119, 121, 123, and 124. Now, my lord, kindly text, my lord, two paragraphs, my lord, I will cite. My lord, kindly turn, my lord, running page 187.
Yes.
Now, paragraph 102, my lord, it says, my lord, on perusal of these samples representations, which you have given above, it is more than obvious that the selections have been totally unfair. The manner in which the interviews were held can be gauged from the facts that on certain days, as many as 300 candidates were called for interview, assuming that after the break of the interview board sat for 10 hours, that is 600 minutes, and this would give barely 2 minutes per candidate. In 2 minutes, one candidate has to leave, another candidate has to step in the room, which the member of the selection interview board be asked to take a seat. The 2 minutes will be over during this process and it is obvious that the interview were a total sham. Now, my lord, kindly text me, lord, the page, paragraph 116, page 190.
Yes.
Now, my lord, may I just place it? Paragraph 116. We live in a country which is governed by the rule of law. The action of each and every official or the government functionaries has to be in accordance with the Constitution. The rule of law is the golden thread which runs through our Constitution. The two most important facets of the rule of law are fairness and equality. Every citizen has a right to equal opportunity of employment and equal treatment at the same time of selection. Nobody can deny this right to any citizen of the country, and if such right is denied, then this court will step in to ensure that justice is done. Next, Lord, paragraph 117. Paragraph 117, I am not reading the entire paragraph. Kindly take note, paragraph 117, last 6 lines. In the present case, the sentence starts with, my lord, in the present case, the less said about the selection process is better. We, with regard to every category of teachers and with every subdivision and division, have been given example which clearly show that there is no method followed by the state in making appointments, and it is more than apparent to us that the appointments have been made on totally extraneous basis without considering the future of the poor students or aspirants of unemployed youth. The whole selection process was a cruel joke on the youth of Tripura, but it is also a cruel joke on the youth of West Bengal. Now, paragraph 118, it says, Lord, that this country, it has to be developed that needs great teacher. The teachers are gurus, and teachers are the guides. The teachers are the mentors, teachers are the philosophers, and it is these teachers who will hold the finger of each child, teach the child, and then lead to the child towards hopefully a bright future. If the selection of teachers is unfair, then we are headed for a society which will be an unfair society.
Ultimately, what the court did.
Now, ultimately set aside. Entire selection was set aside. Now, kindly on page 192. Relief. It starts at page 191. Page 121, relief. 191, bottom. Has you also got in?
Yes.
It has been urged that even if we set aside the selections, our judgment should be the prospective in nature. It has also been argued by Shankar's senior counsel for the petitioner that those portions of the policy which are bad may be severed, and those portions which can be upheld can be retained. But the appointments already made need not be disturbed. Reliance has been placed such and such, such and such. These judgments have no applicability to the cases in hand, and we are not at all in agreement with this
challenge.
Yes, Supreme Court upheld it. Next, that is, my lord, page 196.
is against this judgment.
Yes. 2028 SSC, page 6. 2028 SSC, page 67.
How can that?
Now, page 198. Your lordship would find, my lord.
Just judgment.
Well, this is not famous or infamous of Tripura 10,000 teachers recruitment scam.
May 2014. 7th May 2014 order was SL.
Yes.
The cause title gives the
Milord,
name.
different appeals were filed, Milord. Subsequently, Milord, kindly see, Milord, page 198. Your lawsuit find, Milord. This is the appeal, Milord. Your lawsuit find paragraph 2. It says, Milord, selection of 10,323 teachers made by the government of Tripura pursuant to the advertisement issued in 2002, 2006, 2009 was subject matter of the challenge before the High Court at Tripura in Tanmay Nath.
Which paragraph you want citing on this?
Now, Milord, in this judgment, Milord, Supreme Court, Milord, endorsed the view taken by the
Very good.
Tripura.
Give us the relevant paragraphs now. 2020 volume 8 SCC page 67.
Paragraph 17 and 18.
Very good. Next.
Milord, may I just place the paragraph 17?
No, we shall go into that. 17 and 18. We have taken note. Yes, next one.
Next one, Milord, 2010 10 SCC 677. Page 208 of this compilation.
Yes, paragraph.
Your Lordship will not allow me, Milord, to place this judgment, Milord, as because, Milord, in this judgment, Milord, 160.
I don't understand. After this also, if you don't see the, tell us the paragraph.
Paragraphs is, Milord, 26 to 37.
Yes, you tell us that.
26 to 37. Well, one paragraph, Milord, kindly have a look, Milord, page 217, paragraph 37. It says, Milord, Section 165 of the Evidence Act 1872 empowers the court. Paragraph 37, Milord, page 217 at the bottom. Your Lordship will get it.
Yes.
Now, Milord, it says, Milord, Section 165 of the Evidence Act 1872 empowers the court to ask the question relevant, irrelevant, related, unrelated to the case to the party to ascertain the true facts. The party may not answer the question, but it is not permitted to tell the court that the questions put to him is irrelevant or the facts of the court wants to ascertain are not in issue. The exercise of power is necessary for the reasons of that the judgment of the court is to be based on relevant facts which have been duly proved. A court in any case cannot admit the illegal and inadmissible evidence for basing its decision. It is an extraordinary power conferred upon the court to elicit the truth and to act in the interest of justice. A wide discretion has been conferred on the court to act on the exigencies of the justice required. Thus, in order to discover and to obtain proper proof of the relevant facts, the court can ask the questions to the parties concerned at any time and in any form. Every trial is a voyage of discovery in which the truth is the quest. Therefore, the power is to be exercised with an object to subserve the cause of justice and public interest, and for getting the evidence in aid of a just decision and to uphold the truth. The purpose being to secure justice by full discovery of the truth and accurate knowledge of the facts. The court can put questions to the parties except those which fall within the exceptions condensed. So, Milord, learned judge was absolutely right in asking the questions, and Milord, just to reveal the truth. Milord, your Lordship, Milord, kindly consider, Milord, today one thing. Milord, the symbol of justice.
Finish of these two, then you say. 1414 SCC 745.
Now, Milord.
This is paragraphs.
This is, Milord, page 234. Paragraphs 16, 19 and 20.
16,
this is 2014 14 SCC 745.
Yes, para 16,
16, 19 and 20. Milord, this is for the ratio, Milord, the meritorious reserve candidate. Milord, a person who is a meritorious reserve candidate should always be treated as unreserved candidate.
Yes.
Now, Milord, last judgment, Milord, that is State of West Bengal versus Boishaki Bhattacharya.
Yes, para.
my lord, it is, my lord, paragraph 43, my lord, you will also get it at page 258.
43.
43. It deals with, my lord, delay, laches, and natural justice. My lord, Supreme Court also said that in these kind of cases where the fraud is apparent, the delay, laches, and natural justice should go. My lord, it says, my lord, paragraph 43 and 44, my lord. I'm sorry, my lord, I should have pointed out paragraph 44 also. 44 says, my lord, it says, my lord, we are of the opinion the principle of natural justice cannot be invoked to validate the fraud that has occurred. The principles are to be rigid and inflexible. Rather, they must be applied with due regard to the specific facts and circumstances of this case at hand. So, my lord, your lordship knows these facts. I am not placing this so far as this judgment is concerned.
Thank you.
Now, my lord, only one thing, my lord, I'll just show to you, I'll just point out to you, lordship, my lord, that
has been what more do you want to show?
My lord, I just want, my lord, so far as justice is concerned. Now, my lord, initially, my lord, the justice, my lord, your lordship note the 2024, the new version of justice has come. My lord, previously, my lord, it was, my lord, your lordship knows, my lord, as a blindfold with a, my lord, sword. Now, my lord, it is, my lord, scale with a constitution. This symbol has changed. Now, my lord, earlier, my lord, your lordship knows, my lord, the a blindfold was put. Well, judges cannot see anything. Now judges are seeing everything. My lord, apparent, my lord, so far as, my lord, this selection is concerned, my lord, your lordship is seeing everything. What is going on? What has happened in so far as selection is concerned? Yes.
Thank you. Yes, who is the next person in line? Yes.
And my lord, other thing, my lord, your lordship, my lord, kindly consider one thing, that so far as, my lord, that Shakespeare's Hamlet, my lord, that something has happened, something has rotten in the state of Denmark. My lord, everything is rotten in the within the administration of my lord both. So, my lord, this selection rightly set aside by the learned judge. And my lord, so your lordship, my lord, kindly consider one thing, my lord, so far as, my lord, relief is concerned, my lord, kindly consider one thing. Today, my lord, learned judge, my lord, set aside the entire selection process. And learned judge, my lord, directed the board, my lord, to start de novo from a particular point. My lord, I would be submitting before your lordship, my lord, your lordship appoint, my lord, any other agency, not this board. My lord, Mr. Ananda Mitra also submitted the same line. Your lordship appoint, my lord, National Testing Agency or any other agency. But this board cannot be trusted under any circumstances. And my lord, if your lordship, my lord, kindly see, my lord, there are so many number of, my lord, applications are filed. In those applications, my lord, number of persons, my lord, cross the, my lord, cut-off marks fixed by the board.
Yes.
My lord, in my writ petition, my lord, out of 130, out of 40, my lord, I can show to your lordship, my lord, 38%, my lord, cross.
You are representing, tell us. Then we will take note of that. Your brother is representing 5. You are representing whom? Tell us.
Lord, I am just assisting your lordship. Nothing more, nothing
less. This is
less.
not assistant, then you ought to have made the entire argument.
Well, I am really thankful to your lordship for giving such patience here.
We need assistance, Mr. Tiwari.
Lord, I tried my level best to assist your lordship.
That we have heard you. But at least I have not seen that there is part argument, compartmentalization, appointment.
That has been, theory has been borrowed from the president of the board.
Anyway, thank you. Yes, who is in next? Yes, sir. Yes, sir. So we have to adjourn for your senior counsel. Then start, sir. Please start. Achha, please start. Tell us what is that. Sorry, you please start. Please start. Ask your senior to come wherever he is. এটাকে বেঁধে রাখো।
Kanoshko, that is can application 5, 6, 7 and 10.
Yes, you are for whom?
And there is a can
You are appearing with whom?
for can application 5 for Priyanka Naskar, that is the main petitioner before the single bench, my lord. Those who have preferred appeal subsequently. And this is the board's appeal. We have made the application before your lordship that addition of party, that is can 5.
Can 5 of
It is arising out of 890.
8, 9, 10. 8, 9, 10 of what?
That is the board's appeal, my lord. We have added as a party in the can 5. We are for the applicant because the Priyanka Naskar.
Which applicant? Which can application? When affirmed? When affirmed? Wait for the application.
Our application has been affirmed, my lord.
Can go
890 can 5 to them. 890.
We are dealing with 150 applications. Please show us your application.
Our application.
You don't know when it was affirmed. Date of affirmation টা বললে ওই application টা
This was affirmed on my lord.
Can 890
can MAT নয়
26
can 5.
9/20/23. 26 9/20/23.
26, 9, 20, 24.
3.
And when was it allowed?
Well, it was allowed on
What is the date of the order? You should have kept it in touch with you. You sit down. Are you leading him, Mr. Majumdar?
Yes.
Then you start your argument, let him give the text later. Yes.
Two things are essentially required to be addressed by your lordships. What the authorities were required to do and what is the fallout of non-observance. And whether in the given circumstances of the case, the conclusion arrived at by the Honorable Single Judge is a possible one. And this may not I'm sorry.
Yes.
And this not in the teeth of the various revelation which had come out in course of the proceedings, vis-a-vis the observance thereof by the parties through filing of affidavits.
Yes. Yes.
Now, time and again, your lordships have been taken not through the rules. Not I won't trouble your lordships with the rules. But not the primacy of the rules was aimed at maintaining a process of selection and selection to find out the best possible candidate. And not in various places of these rules, there is conscious use of the word panel at some places and panels at some other places.
Yes.
But I believe it would not be anybody's case to adhere to the provisions of the General Clauses Act and say that this panel would also include a plural. Because not panel means a list of names of the eligible and selected candidates for appointment as a teacher in primary schools published by the board. So the duty to publish a panel is vested in the board. Per contra, the language employed in somewhere else in the rules where it says that panels are to be prepared. So preparation of panels at a different level is not the panel to be published.
Yes.
But the board was categorical in its stand in the opposition that it has not published the panel.
No, they have not said that.
But the opposition I shall come to.
They have not said that
There is an
we have
opposition.
published.
Yes, yes,
The
there is.
form may have been disputed.
There is an opposition to the writ petition where they have said that we have not published the panel.
Show us that.
Page number টা বলতে।
Which affidavit you are referring to? That panel was not published.
এখানে পাবেন না শিল্প, যেটা পেজ নাম্বারটা ইন্ডিকেট করে দিয়েছিলাম।
So your argument was that one panel was to be published. May not be that the preparation of the sub panels of subcategorization also needed publications.
Now please come to the rule.
Yes. ওইটা যেটা দিল ওই কপিটা একটু দেব। আচ্ছা এখান থেকে নিয়ে নিচ্ছি। Yes, rule 6.
Yes, please come to, straightway come to note 2.
But ask him to find out where is that
Yes,
statement.
yes,
Note 2.
Note 2 of rule 6.
অ্যাপ্লিকেশনটা বের করেছো না পেয়েছো কি ও
Not necessary. Not straightway comes to rule 8. Rule 8. I'm sorry. But I straightway take your lordship through sub rule 5.
Yes.
The selection committee shall prepare separate council-wise panels as per procedure below. Firstly, the selection committee shall segregate all eligible candidates applying for earmarked vacancies as mentioned in note 7 to rule 6 from other successful candidates. Secondly, the selection committee shall prepare the following panels for successful candidates who have applied for non-earmarked vacancies. A panel of all selected candidates in a district, namely unreserved category. So a panel for unreserved category comprising of the names of the candidates belonging to general category and reserved candidates of the scheduled caste category, scheduled tribe category, OBC A category, OBC category and PH category according to descending order of merit as per existing vacancies medium wise. So a panel in each district category wise and medium wise.
There is no obligation to publish this.
I'll show. Not good. Of course there is. Then please come to B.
Now you said that there is a provision for publication of one panel, but separate sub-panels was not required.
No, how a panel is to be prepared?
No.
What is
Was that your argument?
What is to be published by the board? All
Yes,
these panels come to board.
we don't know. What is your
Board-
argument?
No, these have to be published. All these panels have to be published.
You just now said that preparation of segregated panels does not require
It's
publication.
one panel each. So there has to be one panel which is to be approved by the board and published. Not how these panels have to be. It is not a single panel. Our panel category wise, medium wise. This has to be published once approved by the board. Our panel in a different category which has to be published once again by the board. Please see the next one. Our panel. It's not a single panel. There are several panels to be.
Yes.
A panel of selected reserved category candidates in a council, namely scheduled caste, scheduled tribes, OBC A category, OBC B category, and physically handicapped candidates in the respective category as per statutory reservation rules from amongst the remaining candidates of such categories serially according to descending order of merit as per existing vacancies in medium wise. 3. A panel of selected candidates belonging to exempted category, ex-servicemen and physically handicapped in a council, separate panels category wise for vacancies reserved for the respective categories.
Yes.
3A. 4. An alternative set of panel of selected candidates for each category in a council. Serially according to descending order of merit as per existing vacancy medium wise.
Now, what is their statement in opposition? All right, come to your next point.
Note, such an alternative set of panel, please see.
Yes, we understood. Yes, what is your argument? There was no publication.
A set of panel of selected candidates for each category in a council. Then note 2, separate sets of panels for all selected candidates applying for earmarked posts as mentioned in note 7 to rule 6 shall be prepared in accordance with the procedures mentioned in clauses 1 to 4 of subrule B. Then note 6 is an additional panel. So note all these prepared panels category wise and medium wise depending on the vacancy position apropos the reservation policy or the laws as applied in the state have to be prepared by each council.
Yes.
And these go to the board for approval. These go to the board for approval. Please come to the next one. Subrule 7. While preparing the panels mentioned in subrule 5 and subrule 6 above, the selection committee shall at first divide all the candidates who will be found eligible after the interview into two categories, trained and untrained, and thereafter two separate sets of panels for each category.
Yes.
Shall be prepared, one for the trained and the other for the untrained candidates. So, for each district, category wise and medium wise, there has to be at least two panels prepared.
Yes.
Notwithstanding anything contained in any of these rules, the impaneled trained candidates shall be absorbed first against the sanctioned vacancies, and thereafter the untrained impaneled candidates
shall be absorbed against the remaining vacancies. Under no circumstances, untrained candidates shall be given appointment of if trained impaneled candidates are available for the respective categories. So for each category, there has to be a panel of a trained candidates panel and untrained candidates panel. Preference being given to the trained categories. If the seats are exhausted, then no further chance, then give up thought to the untrained candidates for each category. Approval of then comes not approval of panel. The panels after being prepared. It's not one district, one panel. Yes. The panels after being prepared shall be accorded approval by the board and thereafter shall be sent to the respective district primary school councils with all necessary papers for appointment. The district primary school councils on receipt of the approved panels shall call the impaneled trained candidates first for counseling for posting in accordance with the vacancies medium-wise in terms of the options exercised by the impaneled trained candidates and thereafter the impaneled untrained candidates in the following manner. Please see what is to be done next. If a reserved category candidate opts for an unreserved post on the basis of his position in the general list or merit panel, he shall not be taken into account for the reserved category post. If, however, this reserved category candidate opts for a reserved category post as per his position in the respective reserved category panel, he shall be considered as a candidate filling a reserved category vacancy of that category, and his candidature in the unreserved vacancy in the unreserved post shall be filled up from the general unreserved panel or merit list. So there has to be a reserved category panel, there has to be an unreserved category panel.
Yes.
Now, the stand of the board in opposition was, I just read from page 389 of the stay application. I just read it, it's in volume 2.
Yes.
Stay application. 873. Paragraph 9 at page 389. With reference to the statements made in paragraph 10 of the said petition, I say that the applicable recruitment rules of 2016 made in exercise of delegated legislative power by the School Education Department never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup of marks, rank of candidates as contended in the writ petition. The recruitment rules has not been challenged in the said petition. Such being the position, respondents cannot be faulted not to have caused publication of the above in public domain.
Where is that provision that you publish it?
Not the definition of panel itself requires a
has to be published. There is any other published reference to this point?
All other provisions deal with preparation of panels and approval of the panels by the board.
No, the panel definition says it has to be published in according to the rules. Where is that according to
the rules are silent.
Rules are silent. So if rules are silent, what is the obligation?
Procedure may not be there.
Procedure,
but
separate panels.
But the fundamental duty to publish remains.
Where?
Not
published in, come to the definition.
Yes.
Panel means a list of names of the eligible selected for appointment as teacher in private school published by the board according to rules. The rules are silent. Then what will be your argument to
The
that?
procedure for publication.
Procedure is separate, a separate panel wise, etc., as you have
No,
explained.
the procedure for publication might not have been spelled out in the rules.
Yes.
But that does not do away with the obligation of the board to publish a panel in accordance with the rules.
No,
Suppose the rules are not there.
Suppose rules are not
Is
there,
it
they
is
are
it an,
taking the plea, we have pasted in the district council.
that is not that will not do because the board has to publish.
Board has done it, approved.
Board
panel
has to
was not
publish the
approved.
panel.
But the rule itself is silent. How
The modality of
publication
publication is not prescribed in the rules.
Exactly. So when the modalities are not prescribed, you have to impinge upon them that they have conducted and followed an illegal method.
Right.
What illegal method they have
But
done?
first of all,
Suppose the rules does not say.
First of all, whether these panels had at all been prepared by the councils.
That is separate. That is another aspect of
So what is approved?
You are arguing on publication.
One
Nobody till now has told us, shown us that publication means uploading in the website or it is uploading in the panels. Where?
Now, modality of publication is not there.
Silent.
The rules do not spell of a modality of publication. It could be a pasting on the notice board or a conspicuous place.
Yes.
It could be an uploading.
No, very good. Your argument is very good. Nobody has till date told us that this has not been told to us, that there does not exist any modality towards publication.
No, the rules are silent. That I have to go by the rules.
Go by the rules, yes.
Now, the panels after being prepared shall be accorded approval by the board and thereafter shall be sent to the respective district primary school councils with all necessary papers for appointment. So, what is approved is
here you are going into appointment letter. First criteria they do not fulfill. That is your argument.
I am trying to draw your lordship's kind attention to a harmonious reading of the various rules of the Rule 8 which may lead to the only possible inference that there is a duty cast on the councils to prepare various panels. In each category, at least 2. One for the reserved trained and the other for the reserved untrained. Yes. Otherwise, the subsequent provisions in the rules, which gives a preferential right to the trained candidates to get an appointment and to exhaust the vacancies, this cannot be carried forward or cannot be implemented. And therefore, not comes the question of preparation and disclosure of panel medium-wise, category-wise, and this reservation-wise. How has this exercise been carried forward, fructifying into issuance of letters of appointment in the absence of panels being prepared?
Yes.
Now, the unequivocal stand of the board before your lordship's court is district-wise we have prepared panels.
Statute does not mandate us. Statute does not mandate. There is no mandate that you have to publish it in this fashion.
We have prepared panels district-wise. And I am not on publication for the time being.
No, that you have shown to us.
I am submitting that the
there are 2 parts. One is publication, the other is preparation. Preparation has to be single panel as the procedure has been laid down.
Not single panel.
Respective panels for the respective subjects, for the earmark.
Medium-wise, category-wise, and even reservation. Now, this has again twofold ramification. One is trained, the other is untrained. Unless one prepares a panel for trained candidates and untrained candidates, then how does one give a preferential right to the trained candidates from that panel?
So we may assume that there is a total nexus. It was one selection process for trained as well as untrained. If no aptitude test is held, then no aptitude test was held for the trained candidates also.
If no test has been held, it has not been held for anybody.
So today, the judgment, if you can come, just a question.
My lord, of course, not it helps to shorten our argument or not to reply to your lordship's queries.
A recruitment process is being challenged. It has two parts, one for the trained, other for the untrained. The Honorable Court proceeds on the basis that it is not the writ petitioner's case concerning any trained candidates. So we restrict ourselves to the untrained.
Right?
So today, if for the lack of aptitude or the other infirmities as have been pointed out by you and others, today we say that this untrained candidate appointment was bad. But on the self-same declared recruitment process which we are asking, which we are being asked to set aside, there will be 12,000 other candidates who would be aggrieved, because then we have to construe that there was no proper aptitude test, no proper publication of panel for the trained also.
There can be two ways of not approaching this issue.
Yes, you tell us what can be the issue.
One is,
again call the trained persons, come and join, we will consider.
Your lordships normally, of course not, your lordships will only decide a lease. A lease.
You tell us, Mr. Mujumdar, how it is to be decided.
Now, Now,
is it then incumbent upon us that I should call the trained candidates also, that see, your employment is also at stake? Because I will be setting aside the entire recruitment process. And the persons you have served, though you are not affected by the judgment, you will now be affected. What should the court do in such a circumstance?
There are instances both ways.
Now, we are asking you
to assist us. There are instances both ways. After all, to court justice, the court first decides and then gives reasons.
What is the solution?
The solution, I had filed an application.
One thing is that, no, we are not, it is a very serious issue. We are dealing with the life and livelihood of 33,000 families. We are asking you that you tell us that then where it is to end. It has not been pointed to us that this is the specific rider nexus of part A, B, C candidate with the corruption. So they must go. It has not yet been shown to us that investigation is continuing. It has not attained final. The unified argument from your part has been that there was no aptitude test. There was total corruption, scam. Now, if the aptitude test goes, the same aptitude test was there for trained candidates.
Trained, of course.
Then what should the court do?
The issue before the court was untrained versus.
If we deliver a judgment today, the point will be then if you are touching the candidates of trained also, because your argument was that without exhaustion of the trained list, the untrained does not come in the picture. So if the trained appointment was totally bad, your exposure becomes more.
Now, the issue before the court was untrained versus untrained.
No, Mr. Mujumdar, you were asking from us that you answered the list. You say whether this sort of a corrupted practice can prevail or not.
I can show to your lordship not instances galore.
When you ask something from us, we also have to question you, Mr. Mujumdar. That Mr. Mujumdar, you tell us today, if I am setting aside the recruitment process and affirming the cancellation of appointment of 33,000 untrained candidates, am I to leave the trained candidates who also got such appointment on the rudiments of a scam? They will not be touched. What will be the answer, Mr.
Not appearing for that.
Think over it, Mr. Moju. Please think over it.
It's not. That will be a separate issue, of course. Not, of course, very intricately connected. Not what will be the outcome of this?
What does the council say? What? Sir, you people you are the top class of the society. You have to say, the advocates are meant for that.
Not the right side.
Advocates are espousing the cause of the people. One is for the persons who have already got service, worked for 5 years. And tomorrow you say you go out of the employment.
They have worked for 5 years.
And at the same time, you say that we have been the perpetual sufferers. We participated, we did everything. Just because we did not pay money, we did not get appointment. Very attractive argument.
Not in so many words, but
the facts, we are expressing what we have.
Not a person who got 16 in total He has got an appointment. I got a particular marks. There are
Certainly.
There are 569 persons working from the same district
So
who
we
got less than me.
appreciate your argument, Mr. Mojumdar.
And
You-
this is
we set aside the entire process.
And this is
Then for
vis-a-vis
that we have to hear the trend also.
and this is only untrained versus untrained.
No, that you cannot restrict.
No. I am when the example that I shall cite.
Your writ petition was what? There are 369 existing vacancies. I have not been treated equally with my counterpart who happens to be an untrained. You just give me appointment in that post. Finished. No rumble, no riddles, nothing. Everything would have been quiet.
Yes.
Then what happens today? We are answering a larger
Today,
issue.
yes, your lordships can't close eyes. You can't close your lordship's eyes to the fact that if I go ahead, somebody else who might have got more than me.
Yes, next, what is your, please think over it. I would request all the advocates to do so.
And in so far as the other party is concerned, that investigation by CBI.
Answering a lease is an issue, but at the same time, you have to, you cannot segregate yourself from
Today, if somebody is not before your lordship, today, if your lordships, somebody is not before your lordship's court who might have got more than me.
Yes.
Might have got more than me, but not been appointed. That is also a possible case.
No, that you can say that even they have not appointment, whatever would be the judgment, it will be applicable to all.
At the same time, there are persons who have procured employment.
So if we today set aside the judgment and say it is a judgment in rain, then the trained candidates who are not parties will also be sent out of it.
In the event your lordships hold that the process suffers from illegality, then this should percolate to every possible end.
Exactly. And then we are hearing the persons who would be affected. Without hearing them, we would be doing.
Right. Now,
there is no answer. To the arguments at once, but it is a serious question. As you are saying, how will you see? I got 15 and did not get the appointment. The person who got 9 is being appointed. Really heartbreaking in a competitive process. So this allegation will again be there in respect of the trained persons. Persons will file addition of party application. Just as it happened today, because if we set aside the recruitment process, then all the persons who come inside the ambit, they get a chance to get the consequence of the judgment direction which we issue. Similarly, trained candidates also this will happen.
For 10 candidates, 15 months different.
This is just a question which has cropped up. We are seeking an answer from you.
But I shall try to not reply it in my way. But not in so far as the trained and untrained categories are concerned, not there are separate modalities of marking. But not this
only
is
one thing left out, training. Other modality same.
Yes, not so far as the.
Yes, why no? Why no? Let us see.
So far as the vivacity and the personality test is concerned, that remains the same.
Thank you for assisting us to that aspect also. We may be wrong also, unless we are pointed out.
But it is there, but not what has not been done by the authority, not doing a wrongful action, causing a large deprivation to us. It's a large scale illegality committed. I'm not, for the time being, since I have not produced the documents or the exhibited materials, I'm not for the time being submitting that it's a fraud. For the time being, I have documents to show that persons who have got 15 marks have been appointed vis-a-vis the untrained category.
If we accept your argument, there's a large scale scam.
Not a scam. I said illegality in observance of the process. I put it in this way for the time being. But where does it result to, and what is the cascading effect of this? But one would be.
30,000 substituted by another 30.
But one would be to recast the entire thing once again. Whatever is available, recast it.
How can you recast, Mr. Majumdar? 1,25,000 applicants.
If there is an illegality,
42,000 selection. Only one judgment has come to us, Tripura High Court judgment, which your brother has just now cited. We shall consider they will answer on that. But our question is, we are seeking an answer that there is corruption scam, this cannot stand. You have to lose your jobs. Then if they are thrown out, these identical riders applied to the said recruitment process. Now the persons who had been unsuccessful as trained candidates, they will also come to us. That, sir, consider my case also. This is the infirmity. Where is the end of it? And remember, in the meantime, their services are continuing.
Right. Does that,
when if we deliver a judgment, say after 2 years, they would be completing 7 years of service. They become entitled to a part of the gratuity and everything, 5 years. Gratuity, government will be settled for this, for the wrong which has been committed, as it has been alleged wrong, I should say.
But today, if your lordships are persuaded to hold that there is a gross wrong, gross illegality.
No, we are asking you that suppose we accept your contention and set aside. We cannot segregate, na? That there had been corruption in respect of
a unified process. That's undoubted. That's the problem.
What can be your suggestion?
But we shall try to find out.
Nobody has told us that. We are hearing arguments from your part from substantial period. Please consider. Anyway, what are the other points you are arguing?
Very good. I'm not. But I was placing paragraph that rule 10.
Yes.
Come to sub rule 2. If a reserved category candidate opts for an unreserved post on the basis of his or her position in the general merit list,
or that this has been shown to us.
And not please come to rule 12. Not much has been questioned about the validity of the panel. Before your lordship's court that there has been large scale rank jumping. Then that will not weigh with your lordship's kind conscience in deciding as to whether these persons should be allowed to continue or not. Trained is one aspect altogether, a different aspect altogether. This is a case of untrained versus untrained.
All right, what is your next point, Mr. Majumdar? Have you drawn up any written argument?
Not till I shall hand up. I have formatted the points. There are only 5 or 6 points. I have noted it down. An approved panel shall remain valid normally for 1 year from the date of approval by the board. Provided that the board may extend the validity of such panel by 6 months at a time, but the total period of such extension shall not exceed for a period of 1 year.
They have said that it has expired on diverse dates in between a particular period.
Now,
that is
there can be no estoppel against me or no waiver or acquiescence against me, because all these things will only operate if there is a known right which I have waived. What has not been disclosed earlier, can't operate against me for the purpose of shutting me out.
That is with subject to some reservations, because the litigations continued from first writ petition was in 2019, I suppose, which was disposed of by Justice Banerjee.
17, man.
17. And in that also, in view thereof, whether you can take this plea that I was totally blind about the entire aspect,
These things,
in spite of being a party to that litigation.
these things have no, some of them were not parties of
Some
course.
not, but some were.
Could have been.
No, not could have been, Mr. Majumdar.
There were nobody has kept a count of the number of applications for
shun out
impeachment.
that on that basis.
No, nobody has probably kept a count of the number of applications for addition of parties filed in different litigations.
Oh, no, they were rich petitioners in those. Justice Orijit Banerjee's judgment is go
That
through
was for the purpose
I
of
may be wrong, just check it out.
publication of a panel probably.
This argument, panel reservation, this rank jumping which you are saying,
right?
This was exactly the point in origin.
This has now come out. This has now surfaced.
No, sorry, it came out at that juncture.
But they have not. They have disclosed it only for the first time before the honorable single judge.
No, it was disclosed at that time. That was the council's argument. Have you, Mr. Majumdar, have you gone through that judgment? Justice Banerjee and Justice Bhattacharya.
Right.
Please go through it once.
I have gone through. Now, I'm not this disclosure of materials and not the district-wise numbering. This has surfaced for the first time in this litigation.
No,
in this round.
to correction.
No, that's title binding surface for the first time here.
Please go through a paragraph.
I'll go through that.
Paragraphs. Yes. Yes. Anything else, Mr. Majumdar?
No, of course not. I have to satisfy. I can't conclude today. Now, I'm not. Please come to. Trained versus untrained, your lordships were posing this question to me. Please come to that schedule once again.
Schedule of
Yes, now please come to that qualification for recruitment.
Criminal
রাখ না হলো
Mr. Mojumdar, you give us an answer on that
I shall try to.
on 11th. And if you can concise your argument, it will help us.
এইভাবে কেন এগুলো বলছি আমি করছি শোনা কাজ শুনে যাবো আমি বলাতে বাবা
I was told Mr. Bhattacharya would also be arguing. Though I have not recorded it, so if you can just convey so that on that day at least he can start. I think he would be covering the arguments of other persons.
I shall try to
if you
also convey your lordship's views so that if you can come
only
with an
request
answer.
you now, if it can be done, and you give a think over this, Mr. and give an answer. Thank you.
Now.
মুশকিল হলো 11 তারিখে বাকি 2 PM গুলো কি হবে 11 তারিখে বাকি 2 PM ওকে কবে রাখলো দাদা